everyone that will be testifying, I need you to stand and raise your right hand. Do you swear or affirm that the factual statements and factual representation which you are about to give or present during this public hearing will be truthful and accurate?
Yes. I do, yes.
Okay, first case.
Yes, if we can, we have an attorney. I wasn't aware until late that he's representing him, which is Jonathan Rodeback. He's going to be representing the Mobile Grill, and we have an agreement, so it should be pretty quick. So I would like to take the second case out of order and start with case number Charlie Echo 21-022282, Liang Inc., and that's 1401 Indian River Drive. So the parties have come to an agreement at this point in time, and Jonathan will testify accordingly. The owner is here if you have any questions for him. What we're going to do is that we're going to agree to give them, because they already complied with one section, which was all the seating. That's all been removed. The only issue they have remaining is the concrete slab, and they want an opportunity to see if they can do a site plan amendment to that one. So we're going to give them the 60 days to get this thing approved, get it forward, and in 60 days to implement it. In addition, Jonathan will work with the owner to get a power of attorney authorizing him to do so. And I'll let Jonathan speak.
Before we get started, I have let the city know, and I've let council know that we work on same law firms. And so the city has not objected. Does your council object to me hearing this?
No.
All right, then we can go forward.
Excuse me, Your Honor. Would you have your witnesses give their names and spell their last names for me, please? Thank you.
You anticipated my next question.
Okay.
You can announce yourself.
My name is Jonathan Rodeback. My last name is spelled R-H-O-D-E-B-A-C-K. I am here on behalf of Liang, L-I-A-N-G, Inc., which is the owner of the property, and also Mo Bay Grill, Inc., which is the tenant at the property. Okay. And yes, as the city attorney stated, there has been an agreement reached. The issue that has been involved in this particular situation is just finding an engineer to get the plans, the most hopeful of which is retired. So now over the course of the next 60 days, what will be happening, we'll be reaching out to engineers locally. If we're not successful locally, we'll go out of the area. That way we can get the site plan application in, get it approved by the city, and then 60 days thereafter to implement what is submitted to the city and approved. We have a head start on what is needed because there has been several discussions between city staff and our client already discussing what needs to be tweaked in order to get it up to compliance with the code. There's certain landscaping that must be installed. I believe there is a trench as well. And also they want to deal with the traffic flow because it was a if you want to call it a homeowner special, a property owner special of painting the lines in that parking lot. So the changes that'll be made will make it a little more formal and official.
Okay, recommendations.
The recommendation is, like Mr. Rodeback said, we'll agree to the 60 days for them to get the site plan going and another 60 days to fully implement it in compliance with the site plan. In addition to, we do also want a power of attorney that he's representing the owner as well. That way, everything's clean and cut when we go forward.
Okay, so are we going to postpone this case, hold it in abeyance, or
in the order, it will give them 60 to 60, and I already advised the owner if at the end of the 121 days if this is not done, the fine will start of $100. So we're asking for everything we normally do ask for, the administrative fees, which we were willing to waive, see what happens down the road, as well as the $100 in this case of daily fine. If after day 121 it's not completed, then the fine will start, and I did advise the owner of that as well.
no objection?
No objection?
Okay, so ordered.
Okay, just give me a little bit of time. Our order was drafted a little bit differently, but I already told Jonathan we'll change the order hopefully by the end, and we'll get him a copy of it for him to sign and for you to have.
Thank you, and thank you for the accommodation on the agenda.
Take care. Next case.
Okay, sir, the next case, which was the first one on the agenda, let me put my earplugs on, is, where's my, there he goes. Back to case number 1, which is case number Charlie Echo 21-034377. Owners is Damian H. and Bonnie Faye Gilliams. Address is 490 U.S. Highway 1. This is the case that, when you're ready, I'm going to present the case, and I have 2 witnesses that I want to be calling. However you want to take the order.
Good afternoon, Your Honor. Thank you for allowing me.
My bad. Good afternoon. Do you plan on presenting any witnesses?
Yes, Your Honor. I wanted to discuss before we got started. I had sent a letter to you. I'm not sure if you received it for a continuance as well.
I did not.
You did not get it. So let me go ahead and give you a copy of it.
Sure. Did the city receive a copy?
Yes, they did.
It was given to the clerk and the PD department. It's my understanding that it was denied by the deputy chief.
I specifically asked to have it sent to you, Your Honor.
Okay.
Just a point of order. Do you want to take things out of order and have him go first, or you want the city to present his case first so he can be able to rebut?
Well, first let me read this. Let me ask you a couple questions on this. What efforts have you made to obtain counsel?
I contacted my existing criminal attorney, who's assisted me in another case, 2 of them. I had a hearing this morning as well at the 19th Circuit Court in Indian River County. So there's been a lot on my plate, and I reached out also to my engineer, Mr. Smith, and because of the holiday and because of his schedule, he would not be available for at least 30 to 60 days as well.
So the only counsel you contacted was your criminal counsel?
That's correct. I needed somebody who specializes in land development, and that was the issue.
How long have you known about this issue?
I've, when the code enforcement officer came to my property and served me.
But how long have you known about this issue?
The code enforcement officer came to my property and served me personally. I had...
You were not aware of this issue before the code enforcement officer served you?
There was discussion going back and forth, maybe 30 days before that, pertaining to stuff that I already had on file. There was also a site plan that was submitted, which I felt to show that we're in good faith. We're making every effort to comply with something we already feel we already complied to in reference to furniture, benches and tables and chairs. So...
When did you submit the site plan?
I would say three months ago, approximately. We have not heard back from them.
Okay. So you've known about this issue for months?
When I'd have to look at my file, I'm sure the code enforcement officer can let you know when he served me, but I'd have
Well,
to...
presumably when you submitted a site plan, you knew that there would be a possibility you might need counsel.
No, we didn't. We felt that we've already were in compliance.
Okay. But yet, even though you knew about this hearing, you still have not contacted any land use attorney?
No, I was reaching out to, again, the attorneys that I was working with, and I have not been able to obtain one that does specialty. It's a small community, and I have to reach outside to Brevard County and outside the community.
But you still haven't contacted them. If you had tried and failed, that might be one issue, but you haven't even tried to contact a land use attorney.
Your Honor, if I can.
felt, Your Honor, I felt that our plans that we submitted, we were not going to need, I was hoping that we would not have to go through that expense. So we submitted the plans that they requested, paid the fee, and we're still waiting.
Okay, so the two bases you list here is your failure to be able to contact a land use attorney and your hearing. Since you already had the hearing and you're here, that's moot.
I'm sorry?
The hearing you had in the courthouse. The two bases are your failure to be able to contact a land development attorney and your hearing this morning. Well, you're here today, so the hearing this morning is moot, but you've had at least a month, if not longer, notice of this issue, but yet have not contacted a land use attorney.
The biggest part of it was the engineer, which required the site plan work, his name is Todd Smith, and he contacted me and said that he could not take this on for at least 30 to 60 days.
Okay.
Your Honor, if I can approach you really quick, I have
Sure.
a July 1st, 2021 letter that went out to all the businesses, including the No Name Bar. This was not signed, it's just a copy I have, but the testimony would have been accordingly. It went out from the city manager and a community director, community development director. So I'm going to approach you, that you can read what it says.
Show it to him first. Thanks.
Yes, Your Honor, I am familiar with this letter, but we felt that this did not pertain to us. We didn't fall in this category. We were pre-existing before the pandemic.
Okay.
So,
Did you make the city aware of that position?
absolutely.
Did the city agree with that position?
They said that to submit a modified, small, minor modification, which is what we did.
Again, if I can, the city did not agree with his position. What the city said was that those chairs were in non-compliance with the site plan, therefore he had to submit an amended site plan, which he submitted initially, a rough draft of one to get some feedback, and the testimony would be accordingly by Dory Bosworth. She gave 5 additional comments that needed to be made. Subsequently, in September 1st, they did submit the official application, which didn't address the complaints, and since September 1st until now, he has not reached out to the city, and of course, the city has not reached out to him, and of course, there'll be testimony about that as well.
Your Honor, we went back and forth as to the letter they originally sent. We felt that did not pertain to us because we were already pre-existing since 2013. So we were going back and forth with the code enforcement officer and land development department. And then we both had an understanding that nothing would go forward until we went ahead and got together and I had to hire somebody, a consultant, to put together some sort of plan to show them where we're putting our chairs and tables. So we tried to, and when we submitted that, Dory had indicated to us that we're good to go until we get back to you. So we were under the impression that we were complying with, and we felt we didn't even have to do that, but we wanted to be a good community business, and that's why we did that.
Well, you
Again,
mentioned that you thought that we had an agreement with whom, presumably you're part of the we, who's the other part of the we?
Dory, when we submitted the application, along with Kurt.
What precisely led you to believe that there was some sort of agreement?
They had indicated that we will get back to you. Thank you for complying. We gave them a check, and we still have not heard to them for this day, and that was 3 months ago.
Again, that's a mischaracterization of what Dory will testify. She did obviously take in the application. She never made a representation that they were in compliance. And mind you, this We started when this letter went out back in July with 8 potential businesses, and that was what the testimony we're going to show today. 8 potential businesses. Out of the 8 businesses, 7 have complied. They moved all their chairs out of the way post-COVID, except for the no-name bar. And that's all we're asking. If he would move those chairs away and let the site plan move forward, then that's fine. But he is not allowed to have those chairs or those tables or bar grills out there until the site plan has been approved. Meanwhile, he's still in non-compliance, and that's what the testimony would be showing.
Your Honor, our testimony will show the complete opposite, that we've been pre-approved by the previous Director of Planning and Zoning to allow us to have stuff out there, and we have that in writing as well. So we would like to get an engineer here, have additional time like the previous applicant did, 60 days, until we get some feedback from the Development Department to see where they're at. And then I can get my ducks in a row with our engineer and hope to get a land development attorney as well.
If I can, if he's willing to move those tables and make it into compliance, we're willing to work with him, like Mobile Grill. They have eliminated all the tables and they are in compliance. Different issues between Mobile Grill and the no-name bar.
Your Honor, with all due respect, we feel we should not be put in that category. We have documentation from the previous Director of Community Development indicating, along with alcohol and tobacco, along with the Health Department for the state of Florida, showing that we have permission to have that stuff out there, and it would do us harm until we make our presentation for us, under a small business in this community, to remove tables that we feel, honestly, they deserve to be there. They've been there and we have testimony to prove that.
You say you have documentation. Do you have the
Yes,
documentation?
I'll be happy to share it with you, Your Honor.
Show it to the city first.
Hey, let her sit down. Dory Bosworth, who's the Community Development Manager and Planner, would like something to add
Sure.
to what he's saying.
Have you previously provided this to the city?
Yes, I have. They have it in their file.
Did you specifically provide it to the city?
Absolutely. I gave it to Code Enforcement Officer Kurt, as well as I made a copy of their file, and I saw it there in their file. So they're aware of it.
Hand it to the city with the documentation.
I think Dory's aware of it, and she's willing to testify about it.
Would you like to?
So hang on, stay right there. So, city, are you familiar with these documents?
So this is not the same document that we have in our file. We have 2 items in our...
Your Honor, that's not what you asked her. You asked her.
Hang on.
What he's referring to is an application to the Division of Alcohol, Beverage, and Tobacco. They required this because he was expanding some alcohol service to outside of the building. We have a copy of the 2013 application that was submitted to them. He is correct in that there is a application from the Community Development Director, Joe Griffin, which what he was signing off on was that the permanent extension of the licensed premises, as shown in the sketch, complies with zoning requirements for the sale of alcohol beverages pursuant to this application. It does not state that he is signing off an approval of a site plan. It just says that he is signing off regarding the zoning requirements for the sale of alcohol.
Hang on for 1 second. If you could show that to him, and I'm going to ask you, are they the same
Well,
document?
Your Honor, with all due respect, she's leaving something out. It's
Well,
not
I haven't
excuse
finished,
me,
sir. I
excuse
didn't
me.
finish.
So hang on.
I didn't get to
We got to
finish.
do this
Okay.
in the right way.
So, all due respect, she had indicated just alcohol and tobacco to you just now.
All right, what-
The application specifies food from the State Department of Hotels and Restaurants.
Right now, I just want to make sure we're all singing off the same,
Gotcha.
Yes.
same
This-
hymnal.
Yes.
Are they the same documents?
Yes, but he is missing a page of that.
Are they the same documents?
I didn't see her documents.
Take
I
a look.
gave her mine, but they are the same.
All right, so take a look. I just want to make sure everyone agrees. Excuse me, can I look them? Thank you.
The document's very complete. I'm not seeing the ones that I have. This is showing that hotels and restaurants is not signed off on.
Okay.
Your Honor, mine shows hotels and restaurants, which is very important to this case, showing eating outside, hotels and restaurant, approved that location.
Okay, so the document you have in your hand
Correct.
is not the same as,
Hers is incomplete.
okay, now,
No,
could you,
this-
hang on, if you could show her what you are addressing.
This was requested from the Division of Alcohol, and this is what came from them. This is what they got from Mr. Gilliam, so it was presented to him.
All right,
Presented to them.
he says that there's something else, so take a look at it.
Yes, on this page, we do not have that. But what he doesn't have is the sketch where he showed where his outside tiki bar.
I have that.
What went to the alcohol, the ABT, was just a sketch that said tiki bar on here. This was submitted in 2013. In 2017, when he brought a copy to Mr. Griffin, because he was also arguing that Mr. Griffin had signed off, he changed that last page
This was
and
all,
added tables and chairs. So what he submitted to the city to show that we had previously signed this off, he had changed this document of what he submitted to ABT. And on that application, it just shows a tiki bar, 2 tiki bars. And he received a call from Mr. Griffin that Mr. Griffin was very upset that he had submitted a document that had been revised.
this is not my handwriting. The attachment I have an identical copy of it, does not show any of this writing. It shows the tiki bar there.
But staff's position is that this is not a site plan. This was just the city signing off that it with regards to alcohol.
We
it was
haven't even
just the
gotten to
zoning.
that point yet. I'm just trying to figure out if we have agreement on
Continuance.
documentation first. So you claim that what the city is providing is incomplete.
Correct, and I can show you that.
Okay, show her.
I did already.
Okay.
Just that one signature part.
Yeah, that's where Joe Griffin signed the same page. Because he had to sign off on the food, the hotels and restaurant. He had to see that part. That was all part of the application. They do it that way for a reason, so that they know they're serving food out there and alcohol.
The copy that he brought to Mr. Griffin in 2017, conveniently, the part where that is a blank page. This document was received from Mr. Griffin, from Mr. Gilliams to us.
Okay. So let me take a look.
Yeah, let me give you the application.
Okay. So he's citing to this.
Yes, and so there's the signature. Now, we have this from, this is a different jurisdiction where we signed this off, which is represented to ABT.
Mr. Magistrate, I assume we're off the record for a second? We're off the record? Are we off the record?
No, we're on the record still.
Okay, then I'm not sure she can hear, the court reporter can hear her talking to you.
Okay. Okay.
When Mr. Gilliams brought
Well,
up.
just hang on. You're right. So, all right, so.
Here you go,
This-
Dory.
This was received from the city, from the state agency.
This one,
This,
yes.
and those are different.
Correct. But this is what we got from ABT. This was emailed to us. Here was our request, and this came from Margie Belton from the FloridaLicense.com. And she sent us this copy. This is what they have on file
That is a copy of the official record.
that they signed off, and this is not included in his there. He doesn't have this last page.
So, Your Honor, with all due respect, the community director, when he reviews these applications, because I've done numerous liquor licenses in this community, when they review them, there's a whole bunch of areas that the community developer's got to sign off on. One is the fact that you meet the zoning. 2, that health department signs off, and you're in conjunction. It's got to be a complete application before they sign off on it. Now, I'm sure if they went ahead and made a request to hotels and restaurants, they will see that there's a complete application there. What they did is possibly got an incomplete from ABT. I'm assuming, I don't know that for a fact.
Did you hear his comment? Because that's my question, is how do we account for the discrepancy? How do we account for the discrepancy?
I think because there is, a lot of applicants will come in, we are usually, on that application, there's only one place where the city staff signs off on. It's usually the community development director. There are many times when that comes in, we are not always the last signature, so we sign that off. The applicant then takes and gets the rest of the signatures and then gives it to ABT, Alcohol Bureau and Tobacco. And so I can't speak for after we sign it. I just know that the 2013 application was what we received from ABT saying this is what we have on file for this particular address. In 2017, when Mr. Gilliams had brought up again the outside seating, because this has been an ongoing case for a few years, the outside seating with no site plan, he again argued that he thought that Mr. Griffin had signed off on it and brought us in 2017 that application. That was from Mr. Gilliams, that we had, it was different from the ABT. And there were
But
additional tables and chairs added.
The discrepancy is not necessarily with Mr. Griffin, but this bottom half.
Your Honor, that's been signed off since 2013. If they felt there was an issue back in 2017, they should have brought this to code enforcement 4 years ago.
But the city doesn't, the city...
I don't want to argue the case right now. That's why I need to have an engineer and attorney available to argue my case. And I don't think it's being unrealistic. I think every citizen should have at least one continuance under the circumstances, and I don't think I'm asking too much. Being that I just saw the previous applicant get a continuance, and for 120 days.
Well, there is an outstanding offer from the city that if you are willing...
It'll affect my bottom line, Your Honor. I'm a small business owner.
I understand, but you have to understand my position is that there is a discrepancy in the documentation. And so you're claiming that you have the authority under this document.
I gave that to them. I gave that to
Well, the
Kurt.
city asked for a copy of the file from the state agency, and the state agency doesn't have this.
What the state would be looking at was that last page, which is the diagram that showed where the outside seating was going to be. That's what the city is presenting that has been changed. What Mr. Griffin signed off on only showed a tiki bar. The one that Mr. Gilliams brought in 2017 has been added tables and chairs, which is not on the copy for the ABT. So whichever signatures are not received within the bulk of the application, the city will admit that we did not, when we signed off in 2013, we didn't have that full one. But that's what we received. But we're acknowledging that the last page, the diagram that everybody is signing off on, one of them shows just a tiki bar, the other one shows tables and chairs. And that is not the one that the city signed off on. And again, it wouldn't have been to sign off the table and chairs, though, for as a site plan, only that those table and chairs met the distances from a church and school regarding serving alcohol, not that it met any site plan requirements.
This is a very serious concern to our business, Your Honor, and we're not asking something out of the ordinary. A continuance is not unheard of under the circumstances when there is discrepancies in paperwork, which will allow them to go ahead and contact hotels and restaurants and get the correct paperwork. I gave that paperwork to the code enforcement officer when he approached my property 4 years ago. And I said, you know, and they never brought anything forward. This is more not an ordinance issue. This is more of a political issue, Your Honor. And I'm not going to get into that because that's not what we're here to discuss. I want to just discuss the facts. But that's why it's imperative that I have proper representation with a proper professional team.
I certainly agree with you that you have the right and the opportunity to have representation. The fault in your logic is that you've not contacted any land use or planning attorneys. If you had contacted attorneys and they were unavailable, that's one thing, but you contacted the criminal lawyer.
Well, no, but the most important thing was the engineer, Todd Smith, and I had contacted him. He did get back to me, and he says, there's just no way I can do it by the end of this, for today, or I can get you in.
Do you have any written representation from the engineer that he's unavailable?
I can show you he texted me.
I spoke to Mr. Smith this morning regarding another project. He was dropping something off this afternoon. I had mentioned that I would be in a meeting regarding site plan for Mr. Gilliams, and he had stated that Mr. Gilliams had contacted him a couple of months ago, but that he was not able to take this job. He was very busy, but he did not relate to me that he was taking the case, but it couldn't be for another 60 days. He just said he was not taking this particular job.
Your Honor, yesterday at approximately 1:15, Todd Smith got back to me, "Damien, I got your message. I'm very overcommitted and cannot take anything else on until 2022." Okay, and then he referenced me to another engineer.
Okay, so
So it's not that it's lack of effort, Your
so
Honor.
even if you got a 30-day extension, the engineer wouldn't be available?
No, that's not true. That's
He
not true.
just said he's not taking on the
But no,
case.
but he also gave me another engineer, and there's other people that I'm reaching out to as well. Like, I have not reached out to, I got a reference from another attorney to Mrs. Zanker up in Brevard County, Kim Zanker. So I'm reaching out to her office. I haven't spoken to anybody there yet because of getting ready for other issues, but it's not for lack of trying, Your Honor.
Well, it sounds like a lack of trying because you're saying you haven't even contacted an engineer yet.
No, I did. I spoke to Todd Smith for trying to get him to pick this case up.
No, the other engineers. You said the engineer in Brevard County.
No, that was the attorney, Mrs. Rizanker, Kim Rizanker. She's up in Brevard County. She's a land development attorney.
Your Honor, we'd like to close out the ABT very quickly, though. I do want to make a reference that the city stands that an ABT authorization, or even if the Department of Hotels said that they signed off, that is not the site plan, a civil engineered site plan, and just that alcohol license does not issue you your site plan compliance. That being said, Mr. Gilliams is saying that he is outreaching to an engineer. On one hand, though, he is saying that he has already submitted a site plan and thought that it was okay and in compliance. So if he thought that was in compliance, there wouldn't have been a reason for him to reach out to a civil engineer. And we do have some information regarding that site plan, why it hasn't been approved to this point. We can go into that if that's what, but there is some confusion on Mr. Gilliams thinking that he still needs a site plan if he is saying that he already submitted one, that he needs an engineer.
Well,
The layout that they requested was for tables and chairs. This is really not even related to engineering per se. This is just an interior outside decorator laying it out along with some additional parking that we've got plenty of. But I cannot make my case, and she's piecemealing her side of the story. I'm not feeling I'm getting a chance to have proper representation so I can properly represent myself and my family. So I don't think it's unreal, Your Honor, to ask for a continuance. I think
I sympathize with your situation, but you were able to make it here, and I do understand you have other obligations, but I see an absence of substantive attempts to contact engineers or attorneys in proper time. So we will go forward with this, and so I will get back to my first question, which is what witnesses do you plan on calling in this case?
I have my son here, who helped along with the application.
Okay.
There's also a customer,
Is that your
son's
son?
sitting back
Come on
there.
up, have a seat down here.
and I have a customer who's been coming to our business for a very long period of time to testify about the chairs and the tables.
Okay, and where's the customer?
She's here.
Does it have the POA? The POA?
I'm sorry?
The power of attorney, is it in there?
Let the city take a look at it. Anyone else?
Now, that's on my side, and I may call.
And you plan on testifying?
Absolutely, Your Honor.
Okay. Just hang on for 1 sec.
Your Honor.
Yes.
I did reach out to an attorney down in Palm Beach, Paul Gugelman,
When?
when this all came about. So, you know, it's not for lack of trying. He recommended me to the attorneys up in Brevard County. So it's not that I'm
I understand,
coming my
but
nose.
it does not appear that you were unable to get representation or an engineer. It just seems as though you could not acquire representation for whatever reasons, lack of diligence.
2 days
or-
before Thanksgiving, Your Honor. It's not easy. And that's why I didn't think it would be unrealistic to postpone this. You know, it's not uncommon, so that we can present the facts.
I understand, but well, we will go forward. So, Mr. City Attorney, have a seat.
I'm sorry, say again, Your Honor? Say again,
Yes.
Your Honor?
We are starting the hearing.
Okay, so you want us to present our case first?
Correct, Your Honor. Correct.
Okay, so the first witness we're going to call is Officer Curtis Bloomfield. He's already at the mic. And he's already sworn in. Okay, can you please state your name and spell your last name and position with the City of Sebastian for the record?
Good afternoon, Your Honor. I'm Code Officer Curtis Bloomfield. That's B-L-O-O-M-F-I-E-L-D.
And how long have you been a code enforcement? I'm assuming you're a code enforcement officer. What's your position?
Yes, sir. My position is I'm the Code Enforcement Officer for the City of Sebastian.
And how long have you been a code enforcement officer with the City of Sebastian?
Approximately 15 years.
Okay, as a code enforcement officer, were you the officer that conducted the investigation on case number Charlie Echo 21034377?
Yes.
So you have personal knowledge of that investigation and the file?
Yes.
Okay, where is that business located and or the address?
It's that business is located at 490 US Highway 1, Sebastian.
Okay, and feel free anytime you need you refer to your notes. Okay, who are the respondents and owners of that property listed on the notice of hearing?
According to the property appraiser's website, it's Damian H. and Bonnie F. Gilliams.
Okay.
Sorry.
When was the initial investigation that was conducted on this property? And again, you can refer to your notes. And for the record, these are CAD notes, and at the end, we'll submit them to the record.
So actually, initially on July 9th, on our approximately July 9th of this year, I visited a property because I received a complaint from Dory Bosworth that it's not necessarily a complaint. The community development department was issuing a letter to all the businesses that had outdoor seating. And what I did was, so I paid Mr. Gilliam's property a visit because I posted that property with a copy of that letter that was mailed from the community development. And so that was on July 9th, 2021.
And for the record, we're referring to the July 1st letter that Mr. Damian Gilliam was referring to earlier?
That's correct.
Okay, and that was signed by both the city manager and the community development director?
Yes.
Okay. So that was the first time you visited when you provided them the letter that, what was your
Yeah.
recollection of what that letter stated, if you could paraphrase it?
It basically stated that the state of, I have a copy right here. It states in part that the state of Florida and the city of Sebastian have recently rescinded their executive orders pertaining to the COVID pandemic emergency measures. And it goes on to say those measures are lifted, and they're given the businesses with the additional seating outdoors no later than July 31st to comply or remove all outdoor seating.
Do you recall how many letters that day you gave to the community?
I delivered about 8 or 9.
Okay,
8 or 9
so-
different businesses, yeah.
So for the record, it wasn't just the no-name bar?
No.
Okay, so besides that letter of July 1st, which you said you posted on July 9th, when was the next time that you conducted any inspection of the property?
About 30 days later, I went there on, actually that's 31 days, I went there on August 10th, 2021.
Okay. And what did your inspection reveal, if anything?
It revealed that the owner at that property did not comply, and the outdoor seating still remained. Not only just that property, there were about 4 properties at that point that had the same issue.
Again, for the record, is there a code or a statute that pertains specifically to this violation?
Yes. So the owner was cited on August 10th, 2021, with section Land Development Code 54-4-18.2, parentheses E, which in part reads, and this is a site plan violation, and it reads, in all cases requiring site plan review, no structure or parking area or part thereof shall be erected or used, or land or water used, or any change of use consummated. Nor shall any building permit be issued therefore unless a site plan for such structure or use shall have been reviewed and approved pursuant to this article.
Okay, we're going to make section 54-4-18.2 part of the record. I want to give Special Magistrate a copy and a copy for the respondent.
Just so you understand, Mr. Gillings, you have the right to object to.
I'm aware of that, Your Honor.
You have any objections to this being made part of the record?
So he only gave me up to D. He didn't give me E, was what he quoted?
It's on the back. It's actually on the back.
Okay, thank you. Yeah, I'm going to object to this part of the code because I don't feel that it pertains to furniture. I'm also going to object to the fact that 18.3 might have something to do with it as well. So yes, I'm going to object for the record.
All right, well, hang on. Come on back. At this point, you can only object to that, not that you don't like it,
No, I understand.
It's just that whether there's anything that has been altered or anything that makes this inapplicable to be considered, not that you don't like it, not you don't think it's relevant.
That. So if you read and you break down E, it says all buildings. This is not pertaining to a building for us. It's talking about structures. We're not talking about structures. We're talking about furniture.
All right, so you don't think it's germane, but you have no objection to it being made part of the record? That
I have it's not germane, and I'm
Is it an
objecting
accurate
to it.
part of the city code?
It may be part of the city code, Your Honor, but it's not germane to my case, and I'm going to object on those.
All right,
on
well,
that purpose.
you can say it's not germane, but you cannot, but it is an accurate depiction of the code, so it can be considered, but you don't think it should be valued highly because it does not apply.
Thank you, Your Honor.
Okay.
That's fine, Your Honor. It is part of our code, and Dory can testify how it's applicable when she testifies. Can I go on?
Please.
Okay. What, if anything, did you observe was the actual violation that pertains to section 54-4-18.2E?
What I observed when I visited that property was the owner had multiple picnic tables, chairs. He had a bar in the parking lot or in the right-of-way area, scattered throughout the exterior of the property.
Did he have like a grill as well?
Yes.
Okay, as a result of what you observed in these violations, what did you do, if anything, subsequent to your initial posting?
I issued a notice of violation.
Okay, and what, for the purposes of the special magistrate, what does that mean that you issued a notice of violation? How was it
It
notice
means I
provided?
found the property to be in violation of section 54-4-18.2 parentheses E. So the property was cited that section of the code.
Okay, and how was the owner provided notice, to your knowledge?
The owner was provided notice, well, I posted the property, and also we sent certified mail, return receipt requested.
Okay. Do you have any pictures you want to offer to the special magistrate?
Actually, I don't.
Okay, can you, he's going to go to the podium now and explain the pictures.
You're controlling it? Okay, so give me the one that says, oh, I'm sorry. So let me have the
Before you
photo
get
that
started,
says.
hang on. Mr. Gilliams, are you able to see these?
This is the first time I saw this from the pictures. I never saw these pictures before.
Yeah, but you're able to see them now?
Oh, yes.
Yes, that one. So that's the posting of the violation. You can clearly see I've left it hanging on the door at the business. That was the initial violation, which is August 10th, 2021. And the next picture that says magistrate hearing, well, that's the posting for this hearing. That's the owner.
Which one are you referring to? The one that they're being held up?
The one that's being held up by the owner, that's Mr. Gilliams.
And that's the notice for today's hearing?
Today's hearing, correct.
Okay, proceed.
Next. Well, actually, well, okay, and that is one of many of the picnic tables that are on the exterior of the property that are in violation of that section of the code that was cited. That's another angle. That's looking west towards US 1. You can see the chairs and picnic tables. Oh, I can't. And that's a shot of the parking area.
Can you back it up, that last picture on the?
Yeah.
Is that the right of way?
Yes, it's a city right away.
Okay.
And that's a shot of the parking lot, part of it anyway. You can see the bar, and there's more picnic tables, and there's some chairs also alongside the building. That's the last one, correct? Yeah, that's it for the photos.
Okay, and these pictures were taken on or about the time that you served him?
Yes.
Okay. Now, you can have your seat now if you want. Are you done with all your pictures?
Yes, I'm done with
Okay. Put it back. You're done?
Yes.
Okay.
Do you
Okay, so,
intend to introduce those pictures into evidence?
We will. You're on all pictures taken by the code enforcement officer on or about the time of service. I'm sorry, yes, all the pictures that were provided by the code enforcement officer will be submitted into the evidence for the record.
Do you have any objection to the
Yes,
picture?
Your Honor.
What's the basis of your objection?
I'm objecting to the pictures with the dog in there. He said August. I didn't get that dog until after August. So there's something not right there. So I'm going to object to all the pictures.
Well, feel free to ask questions of the officers regarding the pictures.
Well, if you want to go back and show the picture of the dog, he said, made a statement that that was in August.
This picture here?
Correct. It can't be.
What-
It's
what do you wanna-
impossible.
what's your
We didn't
question?
have that dog in August. We just got it. When did we get the dog?
September 5th, Your Honor.
September 5th. So, again, I'm going to object to all the pictures now.
Okay, hang on, stay right there, stay right there.
Your Honor, I can get the date for you. I also have photos of that same day if you like.
Okay, hang on for a sec.
Mr. Bloomfeld's looking at his folders, at his CAD notes.
Actually, I did not say, Your Honor, that those pictures are from August. What I said was that was the day of the posting for this hearing. Those pictures were taken the day I posted the property for this hearing.
What day would that have been?
I'll tell you, I'm trying to find that. But I had it right here. That was on October 21st.
With that clarification, do you have any other questions of the officer?
No other questions. Well, I do after, if he's finished with his presentation, then I'd like
Just
to...
these pictures?
No,
No more questions?
If you can just go back and show me the pictures again one more time. Okay. 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 Thank you, Your Honor.
Sure. Continue.
Okay, again, Officer Bloomfield, as a result of the posting, has the respondent complied?
No,
So to this date, the respondent has failed to comply.
that's correct, yes.
So I know we kind of went ahead of each other, but after you said you posted for today's hearing, which was the picture with the respondent holding it over his head, correct?
That's correct, yes.
Okay. Also, you also sent it certified return receipt, correct?
That's correct.
And the record will reflect that it was what, signed or not signed?
I'll have to ask the administrative assistant, was that letter signed? Yes.
While she's looking for that, the record will show that it was actually signed on August 25th, and it was signed, and that would be part of the record as well.
Objection?
Your Honor, pertaining to one of those pictures, I just had one question. If you can put up the picture of my front door where he put the documents, that right there. Sir, with all due respect, but that was in August you posted that sign, the violation?
Yes.
Okay. Your Honor, with all due respect, my son, the sign's up there, he didn't start running until after August. So that's my son's sign that he's using for office, and that got posted thereafter.
Your Honor, if I can,
So I'm
issue is
going to object
notice.
to that as well.
Hang on, stay right
the
there.
issue is notice. He's received notice. He's here today, clearly that he has received notice. So I'm not sure what the objection is. He's holding it over his head, which today's hearing. So I'm not sure what the objections are, but these are pictures. The property was posted. It was sent certified return receipt. It was signed by them, and we have the respondent filling the paper over his head that he received it.
He
Your
has
Honor,
the right to object to the authentication of the photos.
That's fine.
and not only that, Your Honor, but I also want to make you aware of the fact that there is a pattern of inconsistency with testimony today, and that concerns me as well. So I just want to make sure that you're aware of that. Thank you.
So, but regarding this picture, do you object it to being introduced into evidence?
He left it on the door. I don't know what it is. He gave me a piece of paper. I'd like to see what that is before I'm going to object to it, because he left it on the door. He could have went inside and gave it to one of my staff. So yeah, I'm going to have to object to it. I have no choice.
But there are criteria regarding how a property is posted.
The door was open. We're open 7 in the morning to 1 o'clock at night. He could have gave it to one of my employees. I'm not sure if we even got that. I don't know, because it's on the door. You can see the door is open. It's ajar. Again, if he has a copy of it, I'd like to review it. If it's going to be put into evidence, otherwise I'm going to object to it.
Mr. Gilliams is stating that he hasn't seen that letter, but he signed for it on the 25th of August. That's the same letter. It's just a copy of the letter that he signed for, of the notice of violation.
There is a ticket there, not just a letter, Your Honor, so it's incomplete evidence. I see a letter and a ticket there.
Where
so
we're at right now is, do you object to the introduction of this?
I'm going to have to object, yes, Your Honor.
And what in particular is your objection?
I'm going to object on the grounds that it was never noticed properly. It was put on the door, hung there. The accuracy of when it was posted, he says again in August, when in fact my son didn't commit to running till thereafter. So again, I'm a little confused. So I have no choice but to object, Your Honor.
City.
It speaks for itself, Your Honor. That's the copy of the letter that he signed for, and we have his return receipt, and he said he signed for it on the 25th. The reason why there's a door hanger attached to it, when I posted the property, there was another violation. I went there to post the property, and he had a trailer. There was a trailer. He was cited for a trailer that was parked actually to the right of that picture. And that's why there is a door hanger, is what we call that. That's in front of the letter. So he got the post in. That property was posted for the code violation, and when I got there to post it, there was another violation that I saw, and I cited him for the trailer.
He said I signed for it. I'd like to see my signature.
And also by statute, posting is permissible.
Your Honor, with all due respect, that is not my signature. I'll be happy to sign for you.
Yeah,
So
Your Honor,
I'm actually now I'm going to object to it.
Your Honor,
That is not
it
my
was
signature.
signed, it was certified return receipt. Mr. Gillum just made a presentation to you that he can go inside, he can give it to someone inside the door. Someone signed, no one said that Gilliam specifically signed it, but it was sent certified return receipt, and it was signed on August 25th. So whoever signed it, additionally to that, we'll give you copies of that, Mr. Gilliam, don't worry about that. We'll give you a copy of the whole file. But it was signed on August 25th by someone on that property. In addition to that, it was posted. In addition to that, he has it hanging over his head holding it.
We're getting off track here. My concern is Mr. Gilliam's contention that the dates are inaccurate because of the political sign. And I want to clear up that.
And not only that, Your Honor, but this is from the United States Postal Service. This is a signature, them delivering, and that's not my signature. My signature's on file at City Hall. I've signed many documents here. That is not my signature, and they know that. So again, there's a pattern here of misleading you, Your Honor.
Right.
Again, that's a USPS.
I'm just trying to address the discrepancy regarding the dates.
Okay.
When would have been the date that this poster, this sign was put on your front door?
Not sure. I couldn't tell you. I'm not even sure if I even got that. I know that he hand-delivered the one that you see me holding in my hand.
I'm talking about the political sign on the door.
Oh, that was... It was right before qualifying was over, right around qualifying time for the city. He's checking to see. That's my son there, and that's his sign.
That would have been around August 30th.
So we can verify that.
Our city clerk is upstairs. I could bring her down.
Sure. You've been previously sworn, correct?
Yes, Your Honor. My official campaign report shows that on August 19th, 2021, that I took an in-kind contribution for campaign signs. I can't tell you exactly the day that I put those up. I want to say I put them up that next week, but that's when I have it on my report, and that's official documents here at the city as well.
So it is possible.
It's possible what, Mr. Magistrate, I'm confused with the whole thing now.
Well, he's contending that the dates are inconsistent because of his son's political sign.
And it's my understanding that that's not even his son's political sign. My understanding is that that was the old Gilliam's sign when he ran for office. My understanding was that the son didn't really invest money on signs. And of course, his reports would show that if he did.
So, Your Honor, according to my, actually, 1 second.
Your Honor, I have a witness that has a schedule as well. Is it possible we can get her testimony before?
I'll do everything.
Okay, it's just...
Perhaps we can take her next.
Okay.
We'll see.
What, you're going to break up my witnesses?
No.
Well, hang on. Let's
Okay, well, Mr. Blumfield has the picture that they took, which was just provided to us by MIS, which has a date stamp that it was actually taken when?
August 30th.
August 30th, and he has it on his phone.
Okay. Okay. All righty. So any other objections to these pictures?
Not to these pictures, except the fact that I'm going to object to that signature on that card.
Okay. All right.
I don't mean to take his witnesses out of order. She just has one statement.
All right. Well, in all fairness, we need to complete his testimony. Then we can address it. So
Okay.
let him finish his testimony first.
Are we done? Where are we at?
12.
About 12? I think we passed that. Oh, okay.
I know we've been beating a horse, but for the record, I need to be clear. To your knowledge, how was the respondents, or were the respondents properly served with notice for this hearing to the November 23rd hearing?
Yes.
And how so?
I posted the property, which I showed in a picture where the owner is holding the post in, and he also received certified mail.
And that would also include the picture that he's holding over his head?
Correct.
And that was
Yes.
for today's hearing?
Yes, for today's hearing. That picture's, yeah.
And obviously, the respondent is here.
Yes, he is.
Is there anything you want to explain to the magistrate, any personal knowledge you have pertaining to the service, or you're good with how you explained so far?
I think I'm good so far. I think, the only thing I would say is, as a code enforcement officer, we strive to, I know I personally, we're fair with everyone. We treat everyone the same. There is no difference. This is not personal for me. I'm a code officer. My job is to enforce the codes and ordinances and statutes of the city of Sebastian and the state of Florida. That's it.
Okay, I want to summarize your testimony. A yes or no answer would be sufficient based on your testimony. So based on your testimony here today, as a result of your inspection, revealed that the respondents were found to be in violation of Section 54-4-18.2, subsection E, which is called the applicability and filing procedures, due to unimproved outdoor seatings, you testified, tables, chairs, bars, and grills, etc. Is that correct?
Yes, that's correct.
Additionally, your testimony here today provided that respondents were provided with proper notice of this hearing by means of hand delivery, posting, certified return receipt, and I'm not even sure if you mentioned that it's posted here in City Hall.
Actually, I did not, but yes, it is posted in City Hall.
So that is correct?
That's correct.
Okay. Also, you testified that as of this date, respondents has failed to comply.
That's correct. Yes.
Further, you are providing this information with personal knowledge of the case as a code enforcement officer for the city of Sebastian that handles this matter.
Yes.
Okay, so final questions to wrap it up. What are you asking the special magistrate to find in his order here today?
I'm asking, Your Honor, to have the owner remove all tables and chairs within 72 hours, and also administrative costs of $100. And if the owner does not comply with the deadline set, we're asking for $100 per day. Fine be levied against property or any property owned by the owners in River County, plus any additional costs that we incur by the according to section 162.09 Florida statute.
One second. Are you also asking the special magistrate to find that the respondent failed to comply with section 54-4-182E?
Yes.
Okay. Go ahead, I'm sorry.
And also, Your Honor, and if the violation is not corrected by the compliance date set forth in the order, we're asking that pursuant to section 162.08, parentheses 5, Florida statutes, to take whatever steps the city deems necessary to bring the violation into compliance at the cost of the owner.
Okay. Anything else? If he does comply, are you asking the respondent to notify the city in any way?
Yes. And so if the owner is willing to comply, I'm asking him to contact me personally so I can verify that he's complied.
And permission to come on the property?
Permission to go on the property, yes.
Okay. At this point, Your Honor, I think I've already moved everything, but all the photos, the catalog reports, notices, the official file, we would like to move everything into the record.
Okay, so ordered. Do you have any
At this point,
any other questions of the officer?
I have no further questions, and I proffer the witness to you or to Mr. Gilliam.
Mr. Gilliam's your witness.
Thank you, Your Honor. He had indicated that he's going to enter into the record his files. I'm not sure what that means. I have not seen all his files, so I'm going to object to that until I get to see him.
You can feel free to review them right now.
He's asking to, Manny?
Sorry, I was talking to the Ms. Bosworth. What was the question, Your Honor?
He has objected to the introduction of the officer's file.
Okay. That's fine. It's part of the record. It's part of the official files. If you want Mr. If you want to voir dire Mr. Bloomfield as to what is in his file, that's up to him. But these are his notes that he takes on a daily basis. It's kept in a normal portion scope of business.
He just wants to review them.
Well, he could have asked for, I mean, Mr. Gilliam has subpoenaed and asked for public records all week long. He could have asked for this file way ahead of time, and we would have given it to him. And there's nothing we're going to hide. But we will give him a copy of the file, Your Honor.
The city's attempting to introduce his file. He has the right to inspect the file, so whether he's going to object to its introduction.
If you want to postpone so we can make a clean copy, I'm not going to give him a copy of my notes, which have notes on them. I'm not sure if Mr. Bloomfield's notes have any notes on them.
I have notes on mine, so I'd have to give him a clean copy.
Okay.
And I'm not sure if the clerk has clean
maybe
copies.
by then we can get this worked out with community development. I'm happy to postpone this for,
Well, he's talking about a matter of minutes, not days or weeks.
Okay, well.
All right, so
if
if we would like to take this case, and we will recess for a second on this case while the officer or the city provides his file.
Okay. Also, maybe Mr. Gilliam wants to call that his customer or whatever to testify,
And
since
we
it's
can
going to be
go back to
quickly.
it.
We'll take her out of order.
I'm happy to do that.
That was my next question.
Okay, sure.
Okay.
Your Honor, I'd like to call Cheryl. For the
Hi.
record, would you give me your full name?
Hi, you were previously sworn, correct?
Yes.
Okay.
Cheryl Lynn Collins,
And your address?
433 Arbor Street in Sebastian.
Okay.
Would you please spell your name?
CHERYL LYNN COLLINS.
Thank you.
So, Cheryl. What is it that you know about the No Name Sports Bar Sharky's Draft House tables and chairs that are located on our property in our grass area, and when did you know about it?
I've been going to the No Name for about 15 years. I'd say at least 7 or 8 years ago they started outside. I've always sat outside because I'm not an indoor person. But with all the COVID and stuff, I really sit outside because I personally cannot be vaccinated for medical reasons. So to me, it's detrimental. I can't go to the bar anymore or can't go and socialize with my friends because I can't go inside.
So what year did you realize that the table and umbrellas and the grill, how long back is that?
At least 7 or 8 years ago.
Okay. And have you ever seen the code enforcement officer come to the property 7, 8 years ago?
No, never.
Have you ever seen him come to the property 5 years ago?
No,
Have you ever seen him come to the property 3 years ago?
no,
No. Have you ever seen him come to the property?
not that I'm aware of.
Okay. And how often do you visit the no-name?
2 or 3 times a week, at least.
Okay. Um, No, Your Honor, you can turn the witness over to the other side.
City?
We were just going to verify if the,
1 second, Your Honor.
Sure.
Your Honor, real quick, just 2 other questions.
Mm-hmm.
Were you served food outside?
Absolutely,
Were you served drinks outside?
absolutely.
Were you served by a server, an employee?
Yes, I was.
Okay. Um, Okay, that's it, Your Honor.
City?
Yeah, I'm sorry, what's your last name, ma'am, again?
Collins?
Collins? Okay, Ms. Collins, my name is Manny, and I'm just a city attorney. Just a couple quick questions. You're not here to testify today that Mr. Gilliam's site plan has been approved, are you?
No,
Matter of fact, you have no knowledge of whether or not, before you say no, let me answer the question. You have no knowledge of whether or not the seating, the chairs, the tables, the grill, any of that that's outside has been approved, correct?
it's been there for 7 or 8 years, so.
So you have no knowledge that it's been approved, correct?
No, I do not have knowledge. that
Okay.
it's been approved.
And you said that you've never witnessed code enforcement coming out there? Okay. Is that a no?
No, I have not.
Okay. You there every single day, 24 hours a day?
No, but
Okay.
I've never seen them in the years that I've been going there, no.
Okay. Obviously, you've seen the pictures here today that the code enforcement officer posted, correct?
I did?
So were you there on the August 30th?
No, I was not.
Okay. Anything else? Nothing further.
Any redirect, Mr. Gilliams?
Would you have access to city files to know that I was served with paperwork?
I don't know.
Would you know how to go about getting access to,
No.
so basically you
Your Honor, it's
enjoyed,
outside of my,
you
my cross.
enjoyed the comforts and the outdoors for at least 7, 8 years, and now all of a sudden, because of the political activity in this community, you feel that there's an issue here now?
Yeah, because, I mean, outside with all the COVID and people are saying, oh, still social distance, still wear your mask and all. To me, it's safer to be outside, so why take it away after 8 years? And you can't go outside anymore.
Okay, well, thank you very much.
Thank you.
Well, can I have a quick
Oh,
follow-up?
do you have
Yeah,
recross?
yeah, I do.
Hang on. Sorry. We have recross.
Are you aware of Mobe Grill seating situation and whether they're in compliance?
Nope, I've never been in there.
How about, are you aware, same question to Paradolia Brewery, that they were also cited for these out chairs?
Never been in there.
How about the train station?
Never been in there either.
How about Paradise Ice Cream? Is that a no?
No.
How about
Sorry?
the Village Tavern?
No, I didn't. I thought they closed down years ago.
Squid Lips Dock area?
Haven't been in there in a few years either.
Portside Restaurant?
No.
So you're not aware that any of these companies were actually cited for the same thing that No Name Bar
No.
has been cited? No?
No.
Okay, what a surprise. Well, never mind, strike that. No further.
Since, Your Honor, he opened the door of other restaurants, I have pictures showing that they're in violation. Can I add that to the record now, or should I do that later on?
During your case in chief.
Pardon me?
Later.
Later. Okay. Thank you, Your Honor.
Are we done?
Yeah.
Thank you.
Have a good day. Next witness, City?
Are we still waiting for to give him the records, or I can put my next witness on?
Yeah, I figured in the interest of time, if
Okay,
the
no, we-
officer is still collecting his records, we could put your next witness on.
Unfortunately, the records, we have my personal notes on them, and so does he. That's why we're trying to get clean copies for him.
I understand, makes sense.
Okay, the next witness I want to call is Dory Bosworth, and she's been sworn. Put it on. Okay, can you please state your name and spell your last name and position with the city for the record?
Dory Bosworth, B-O-S-W-O-R-T-H, planner and manager of the Community Development Department.
Okay, and how long have you been the manager and planner for the city of Sebastian?
I've been in the planning department for 27 years and the last 7 years as manager.
Okay, in your positions, both positions with the city of Sebastian, are you personally, or were you personally involved with case number 21034377 dealing with an amended site plan?
Yes.
Okay, prior to COVID, I think there's been testimony about this, but prior to COVID, were the codes, to your knowledge, were the codes relaxed in order to accommodate for the 6 feet distance and things like that?
Not so much prior, but because of COVID, during that year, especially with the emergency measures that the state brought down, a lot of our restaurants were allowed to expand outside seating. To add to that, though, just as a clarification, outside seating for any site plan does require parking. It's considered a seating area. So it's not just the table and chairs, but it's a use of the restaurant, use of the bar, and our code requires parking. There are parking requirements for all uses. So because of that, that's the site plan issue, is that when you add outside seating to your property, and it's not based on tables, it's based on square footage, that is an intensity, an increase of the use of your property, and that is why the code requires some additional parking. Now, sometimes that additional parking requires impervious area, which then goes to drainage. It can trickle down, or it can be as simple as you have enough parking, but we have to verify that through the site plan process. But during COVID, a lot of restaurants that either had outside seating expanded, or those that didn't have outside seating added those so that we accommodated our small businesses to try and keep them open. We also relaxed signage, feather flags and temporary signage. There was a lot of things that we just were not proactive during that last year and a half because of the COVID measures. And so once those emergency measures were lifted, the city sent out, I thought, a very nice letter that said, hey, we want to continue on with our community development in accordance to our land development code, and we're requesting not only those that expanded for COVID, but those that we knew had unimproved outside seating areas. We sent them letters to kind of put them on notice that we were going to deal with this. We gave them 30 days. Got to be honest, during that 30 days, there was an increase with Delta cases. We felt bad that we had just sent that letter out. We expanded that, and that's why we didn't send letters to the special magistrate to almost 30 days ago until the cases had done. But yes, your question was regarding that, yes, I'm familiar with the case, and there was some other cases that had outside seating that needed to come into compliance.
Okay, and the letter you're referring to is that July 1st letter signed by the manager and your boss, the Community Development Director, correct?
Yes, this wasn't necessarily complaints. It was just an overview by the city manager and our department that we would like to take care of some of the items, some of the seating and signage that was not in compliance per COVID.
I've only seen a draft of it. Do you actually have one signed by both parties? I'm just curious.
This was the letter that was sent out. They should be scanned. We possibly have those signed ones. I know that they were delivered. They were sent both to the property owner with their tax mailing address, and then also sent directly to the business building.
Okay. Okay, initially when that letter went out, how many vendors and or businesses would you say were impacted by this decision?
There were 8 properties that had non-complying outside seating that didn't match their existing site plan.
Okay, so 8 potential property owners were given this letter that they were not in compliance.
Correct.
And the letter would then follow up that they need to come into compliance.
Correct.
meaning then that all these 8 vendors, what we wanted them to do is remove their chairs, remove their tables, and make it into compliance for site plan, correct?
There was a couple options you could do. You could remove the outside seating, or in our letter, we also said to contact staff that we would work with you to modify your site plan. So you could modify your site plan and we could get that seating approved, or you could just remove the seating and that would put you back into compliance.
Okay, well, perfect. So out of those 8, how many went for the second option, which is to modify the site plan?
I believe right off when the letter went out, there were 3 properties that removed the seating. There was 4 or 5 that did contact staff. We've approved 3 site plans that have come in to ask to be modified, or there were 3 site plans submitted to ask to be modified. Otherwise, they either had the parking, we modified their site plan, or they had just removed the seating.
Okay, so it's your testimony that 3 immediately removed the chairs and tables, correct?
Yes,
3 then went for option B, which they decided to modify their site plan, correct?
yes.
That means that there was 2 left, which I assume was Mobile Grill and No Name Bar, correct?
Correct.
As of today's hearing, how many were not in compliance with removing the tables?
Just this one. The Mobay case is for something different than outside seating.
Okay, so, and everyone has complied with the July 1st letter except for which company or which business?
The case presently, the No Name Bar.
Okay. So you started with 8 cases and you're down with 1, which is a No Name Bar, which refuses to comply, correct?
Yes. So there were, to lead into that there were, of the 3 that came in, or the other ones that came in to modify their site plan, we did have 1 that did not have the parking on their site, but they had to pay parking in lieu. They purchased exemptions. They had to pay they volunteered but paid $6,400. Of all of the site plans that came in, though, they were reviewed and they were able to be approved because they came in on civil engineered drawings. They had current surveys and they had current parking calculations on them that staff was able to adjust based on their outside seating. It was not a full review. They had dimensions on them. They went through the process that we were able to take in their application and review those plans.
Okay. Take that one step at a time. So have you personally had any conversation with the owners at the No Name Bar?
Yes. On August 11th, Mr. Gilliams and his son did do what we call kind of a pre-application meeting. They did come in based on receiving their letter to see what they could do. We pulled their project file. We went through it. I explained that what they would need if they wanted to keep the seating, but to make it formal on a formal site plan through a site plan approval. And we went through that file and we kind of went through with what they needed. I have in their file, I don't know if we need to go into details yet at this point, but what we have, it's an old site. That site's been here very long. And what we have is a 1992 survey that is not scaled. It is 11 by, sorry, here we go. This was the site plan that we have in the file from this old site. Not scaled, not signed and sealed. This is what we have.
If you want to approach the video or that camera.
Before you do that, show it to him. Mr. Gilliams.
We have copies.
No, show it to Damien.
Yeah, that's what I did.
Oh, Mr. Gilliams, sorry.
I'm going to object, Your Honor. We turned in a 11 by 17.
This is just
That's not what her testimony is, Your Honor.
This is just an explanation of what we went through on August 11th.
Yeah, I'm going to object to this.
And what's the basis for your objection?
That's not to scale. The one that, there is one in there for scale, and they're just misleading.
This was just what I had shown them that was in the file. I do not have any full-scale site plan that showed parking and drainage and all of that.
So that is what we have in the official city file.
Yes.
Pre-existing, before this matter.
A site plan that shows parking and parking numbers.
Right. But that was not related to this. That was just in the file before this matter came up.
Correct. And so what we were explaining, though, is for a new site plan for staff to be able to review what we were going to need, that I requested something new, a new civil engineer drawing, a new, I believe maybe Mr., I didn't know how far you went back, but this is not a site plan, but there is a full-scale property in here.
But the purpose for this document was simply to demonstrate that what was in the file
Was not
before
adequate.
this matter.
Correct, and it was not adequate for us to be able to review outside seating areas. It had no parking calculations, it had no dimension. In 1997, it was used...
Hang on for 1 sec. Do you still maintain your objection, Mr. Gillings?
Absolutely.
Even though, given the explanation of the witness?
Yeah, I'm going to object to that document, absolutely. Yeah, it's not accurate.
That it
And
wasn't being presented at that point.
I've got
For
other
accuracy, it was
documents.
simply acknowledging that was what was in the file.
Correct.
Yeah, can I see that again, please?
All right, here's your copy.
Again, Your Honor, we're just presenting what was in the file when they came and submitted whatever document that they submitted. Dory was offering that this is what we have in the file, and they had to amend it.
Again, I'm going to object because I went for fence permits for this property, and we submitted to scale for those fence permits. So they should have it in their file. This is not accurate. This actually, I'm not sure where this came from, who drew this up. Being that this building was built in 1975, there was very limited site plan requirements at that time, and we're grandfathered in from that. What we're doing here is a minor modification, and now she's telling it, I'm hearing the same civil engineers, stormwater, landscaping. I've been through this with these people before. It's called put the goalpost up, and you try to kick it to go through to be nice. And then they go, well, we're going to do it this way. And then you got to try again. I can show you files, Your Honor. They have a pattern and a record of doing this to people in the community, and it's selective enforcement is what I call it. So, but I'm going to object to this.
Overruled.
Again, all
Overruled.
we're asking him is to remove...
Overruled.
Okay, thank you. Go ahead and go up. Mr. Damian, can you please step away? Go up there and testify to the document you want to show him. That document. Go and show what it was. And just explain to the special magistrate what you're showing him.
Yeah, so the only thing I was verifying is that when they came in for I'm sorry. All I was showing was that when they came in for their pre-application meeting, hey, staff, what can we do to get in compliance so we don't have to remove the tables? I was just referring to this old document stating that this is the survey that we have. This is the survey they used to bring in their September survey, just a blown up version of this survey. But I was letting them know that it didn't have dimensions on, that we were going to need something else and an updated survey, which is what we request for all of our site plans. If you've got a 30-year-old survey and you need to update your site, we are requesting that those owners get a newer site survey. And we have many other businesses that we have recently requested that when we're working off a 40-year-old survey. So this was just showing to them that this was not going to be applicable for us to be able to calculate parking and square footage and dimensions. And if I can go back to my notes then on that meeting.
Okay, go ahead.
I'm following up on Mr. Anand's question that what kind of correspondence that I have with the applicants. So on August 11th, they came in and we had kind of a pre-application meeting. I let them know that what we were looking for, it would require an application, that for us to calculate, and that I did help them, letting them know that it didn't mean that they were going to have to supply more parking. It did not mean that we would have to remove all of that. But we needed to verify that they had enough parking to accommodate the outside seating areas based on their square footage and the capacity that they had in the bar. And I did not tell them that they needed new landscaping or anything. We just wanted to verify parking. And some of these tables, as you could see from the pictures, are close to drive aisles that we may needed to relocate those for pedestrian safety and for customer safety with the drive aisles for the parking area. So we discussed what we would need. I was clear that by submitting the site plan, it did not necessarily mean that the nonconformities went away, only when the site plan was approved, but that I would let code enforcement know that they had stopped by, and any activity, if they submitted a site plan, that we would let code enforcement know where they were with their case.
Okay, let me just stop right there, because Mr. Gilliam testified earlier that the city told him that when he submitted that, he was in compliance. So that is incorrect. That's not what you told him.
Correct.
Okay, keep going.
On August 25th, Mr. Gilliam Jr. emailed me a conceptual site plan drawn on this survey, but he enlarged it and did color code it, and it was a conceptual. And I emailed back stating that I wasn't sure if this was his formal submittal. Was this just a cursory staff review? And I have the email where I sent him 5 comments regarding changes that I could see up front, what was going to happen, what we would need changed, or additional information that I would need so that I could process a formal application when it came in. On 9/2, a formal site plan application was submitted on an enlarged survey.
To scale.
Okay, let me just go back while you're looking for that. So you said you emailed who, Mr. Gilliam or his son?
Definitely his son, but I can verify if yes, definitely his son. I did not CC Mr. Gilliam Sr.
But you sent it to his son?
Correct, because that's where the initial email came from.
Okay, that was the initial email. And did he respond to that email?
No.
Okay, go ahead, proceed.
On 9/2, then, we did get a formal site plan application. Like I say, it was the same plan. It is enlarged. It is not to scale because the survey has been enlarged and it wasn't the full-size scale. But it did not have the information that we needed to process it. I can verify that then on 11/8, staff went to the site. We took some measurements. There was myself and somebody from the engineering department. We were able to measure off the items that we needed. With regards to that, I can verify that no, to date, from that September 2nd application submittal date, staff has not formally sent anything to Mr. Gilliam's with regards to formal comments of that site plan.
Why is
But that is not necessarily because of this particular address. As with the same reason why it is hard to get a civil engineer right now or a survey, there are a lot of development applications in and being reviewed, and staff is behind on every site plan, not just this particular site plan. And I have some other sites where it has taken us about between 45 and 60 days to get a first round of comments off to those. So this is not just highlighting this site. We have other applicants and applications that are also behind. So at this point, again, we're not asking them that they can't, we're not proceeding to saying that you can't have any outside seating. Certainly other restaurants, other businesses in town have outside seating. We're just asking him to remove these seats because they're not tied down, they are not structures, they're not sheds, they can be moved until such time that the site plan is reviewed and we verify parking and traffic and pedestrian safety. And at that point, based on an approved site plan, some of those chairs and everything can be put back.
Quick question on the violation. Is what we're referring to, which is outside seatings, is that a violation of section 54-4-18.2 subsection E?
Yes, because as stated, it says no structure or parking area shall be erected or used. There are parking areas and green areas that are being used without an approved site plan.
Okay. Do you have any personal knowledge whether Mr. Gilliam's or any of the respondents and or the no-name bar has previously submitted site plans to the city over the years?
Well, I'd like to quickly, because it can take a lot of it, but regarding Mr. Gilliam's and the issue that he brings up that it's been there for 7 or 8 years, and Mr. Gilliam's is correct, and the city has not been proactive on getting that into conformity. We felt that once the COVID was done, it was a time to get all of the restaurants, anybody that had nonconformities. What I have found as a record, and Mr. Gilliam's is welcome to get copies of all this if he wants, going back to 1993, I found correspondence in here that when events were going on at the park, that there was a temporary tent that would be set up so that Mr. Gilliams could offer to, the crowds at the park for the event so that he could do some outside service areas. He did approach the city. They came back to say that it wasn't it would have to be done through a temporary use permit because the tent itself wasn't a structure. It then goes into 2003 where the matter was also brought up again to get something permanent outside so that instead of having to do temporary permits to set up some outside seating areas when there were events at the park. There's some correspondence in that file. There is also a 2003 application that Mr. Gilliams did for a site plan modification to get some outside seating and music areas. It was never approved. There are notes on this because there was no scale, there was no drawing that was to scale, there was no number of spaces marked, there was no landscape plan, and he wanted a temporary tent approved instead of a permanent structure, and staff said that he would have to get that approved by a tent approved by City Council. It was, again, hand drawing on this plan, was never approved. So again, we were using this 1992 survey. In 2013, there is a building permit, which is in the building permit files, not site plan files. There is an application for a fence, and it's for a 20-foot length fence, 6-foot high, to keep property from being stolen behind building. And he does, again, use the 1992 survey. It shows where the fence is, and it does not establish any seating areas or behind this fence. It was used for protection, and I remember possibly him coming in to see if he could put a couple tables behind there for smoking. Staff did not sign this off because it was part of a drive aisle. He has a circular drive aisle around his building. Staff did not sign it off. It went before the city manager, and the city manager signed it off, which I have a copy of that approval that clearly states by city manager. Again, just for the fence, for protection, it did not establish any seating areas. So in 2013, there was no approval of any outside seating areas. It came up again then when, for whatever reason, it was brought up to us with the copies of the ABT applications that we had before. So I will testify that there is nothing in this file that has approved site plan for any of the outside seating areas. Staff is not opposed to any of the outside seating areas as long as we can verify that there is enough parking for it and we have an approved site plan. The site plan that was submitted in September, there is a lot of motorcycle parking in a stormwater area, and staff feels that I know that there's nothing that has been, which these will be a part of the comments that will be sent to the applicant when there's a formal set of comments sent to you with review of this application. But the applicant is kind of stating, hey, we thought we were all approved. If you were approved, I'm not sure why you didn't implement that additional parking that you're going to. Or when you got the notice to appear before the special magistrate that you didn't pick up the phone and say, Dory, is our site plan approved? We haven't heard from you. So there's been no activity of the applicant to call staff to find out the status of his site plan review.
Okay, I got you, and that's great. You've answered all my questions, but I do have one follow-up. Just for educational purposes to the special magistrate, can you explain to him so he can understand how does a site plan procedure work? What needs to be done?
Application comes in. We usually need some sort of decent plan that has a current plan within at least 8 to 9 years, 10 years. It has the dimensions, parking calculations, site data, impervious. I mean, those are the stuff that we would like to have on a plan. But we try to work with each individual with what they have in their site. Again, the other three that did modify their site plans had current 2015, 2012 plans that we were able to use that had parking calculations, and it was clearly drawn. So what was submitted in September with the site plan.
Well, I want you to back it up. Just what is part of the procedure? So once they submit an application, what needs to be done? You, approve it, or what happens?
There are thresholds that city staff can do administratively. Otherwise, over some other thresholds, it has to go out to other jurisdictions. This appears to be something that we could approve administratively once it's reviewed. We usually send it to our fire marshal building department building official. He kind of reviews for handicapped accessibility, any fire truck issues that he may have. And depending if there is a change to stormwater that would go to our engineer. We felt that it would just be between staff and building department at this one. Once it's reviewed, we would send comments to the applicant. Then they have the opportunity to change their plan, submit it back to us. If all of our comments have been addressed, we usually stamp that plan with either a Planning and Zoning Commission stamp or staff stamp or city engineering stamp, whoever approved that plan. And that is why we require at least 3 copies up front, because a copy of that plan goes back to the applicant.
And you mentioned earlier that you made several comments to the conceptual plan. Those weren't addressed in the September 2nd official plan that they submitted, correct?
Again, we had done a cursory review of the formal application just to see if they had been met, and no, most of these comments had not been addressed.
Okay, so as of today, then the no-name bar and the respondents are not in compliance if they have those chairs, tables, bars, and grills outside?
Correct.
And to your knowledge, as of this date, they haven't removed and they're still in non-compliance?
Correct. And to verify, this is just for outside seating. Usually outside cooking areas and fire pits and things like that is something totally different. So we usually just review for seating area, not for outside cooking areas.
Okay, I got nothing further for Ms. Bosworth. I proffer back to the Special Magistrate.
Thank you, Your
Your
Honor.
witness.
Just for the record, you said you were with the city for how many years?
27 years.
Okay. And your qualifications, you're a certified engineer?
No,
You're not a certified engineer. So you review site plans, right?
Yes.
Stormwater, right?
No.
Landscaping?
not totally stormwater. Overall,
Site plans, you review them, but you're not a certified engineer.
correct. We
Thank you.
usually have a city engineer on board, or we have consulting engineers who review it. But this site plan wouldn't have tripped that.
Okay,
It was administrative approval.
thank you. I just want to get clarification on your qualifications, that's all. You said that the city manager, Joe Griffin, signed off. Can I see that document?
At the time, that building permit system required you to go in to, and bear with me, I've got a lot of papers here. I actually have a copy for you. If I can put it right here real quick.
Put it over here. Yeah, I just want to see, you said that this is a building permit application,
Correct.
and you said the city manager signed off on this?
The third page, he did not
Yeah, I
sign
see
off.
that. It
Yes.
shows that he reviewed this, correct?
Well, it just shows that we were told to sign off on it. It says, okay, per J. Griffin.
Gotcha.
And
Okay.
the reason why it was taken to Mr. Griffin is because staff realized that the traffic aisle and parking was all going to be blocked. And Mr. Griffin
That's
said sign it
exactly
off.
what I was going to lead to my next question.
But for fence, it was for a wood fence.
Yeah, and by the way, this is back in 2013. Joe Griffin was not the city manager at the time. He was the building community development director.
I believe he was city manager. And I did not know that was going to be one of your questions. I could have checked that.
Well, just for the record, Your Honor, I did apply for a permit that affected my site plan traffic driving, and they were aware of it, and they asked for me, they knew that I had applied for outside seating and serving of alcohol, and I had to get that through the state, alcohol and tobacco. That's why Joe Griffin reviewed it, signed off on it, and the eating health department had to come out and sign off on it. So now we're connecting the dots, Your Honor. Now you can paint the picture here. So this was not just a matter of building department signing off on an application. This is the city manager, well, at the time, the director of community development to become, I guess, the city manager, and we can verify those dates.
Your Honor,
Excuse
is
me.
he arguing or
Excuse
is
me.
he asking the witness questions?
Excuse me. So get to this document
Hang on,
here.
Mr. Gilliam.
We proffered the witness. He can cross the witness. If he wants to make closing statements, he can make closing statements.
So let me just ask you to
Okay.
limit your participation in this to questions of the witness. When we get to your case, we can hear that.
So, for the record, on here it says that this was reviewed by the zoning, community development, and approved. And this affected my site plan with the driving. Can you come in and just confirm that?
This did not affect your site plan. It was what was being approved, and that is your copy. What was being approved was what was highlighted in the front page. 23 to 24-foot length fence, 6 foot high, to keep property from being stolen behind the building.
Well, that
Because I
was-
remember at that time you were contacting Mr. Griffin stating that you were having a theft problem and you wanted to put this fence up to keep your property safe.
Right. So, I had given you a document up there with the application that Mr. Griffin signed off on.
Okay, feel free.
And Your Honor, I'm not sure if some of these were our originals, I just want to make sure these two are our originals.
If you're going to testify, then have the mic on.
She's checking documents.
Okay.
Make sure it doesn't take her original.
So we're, excuse me, if we're testifying on the record, if not, we're off the record. So we're off the record. All right, back on.
So, this document reflects, and I can show it to her.
Yes, to verify.
The mic is not on.
This is, yes, it is his signature to verify that your sketch is
Yes, what's the date?
November 13th.
I see the date being 11, let's see it.
November 7th, 2013.
Yeah, so then where do you get, okay. So where did you get November 13th?
It says 7 November 13th. Mr.
Okay, so it was
Griffin was in the
November
military.
7th.
Yes.
And that's his signature as the Director of Community Development, charge of planning and zoning, correct?
Okay.
Okay, is that a yes?
The city manager can sign off on this form, too.
Okay, because he signed off on the building permit on the 8th, according to that document, which involved that area, the fence, which was part of this application that shows the tiki bar, the furniture outside the building.
Tiki
Okay.
bar, no furniture.
Your Honor, this is furniture, tiki bar, chairs. You can't set out a tiki bar without chairs and tables. You can't serve people, okay? So they're splitting hairs.
Again, is there a question
my point, Your Honor,
to
my
the
point is
witness?
this.
Your Honor,
Excuse
Your Honor,
me, I
seriously,
sat here and
I'm
I
not
didn't
gonna,
interrupt
hold
you.
on, Mr. Gilliam. I control this hearing and so does the special magistrate. We're giving you an opportunity. So if you have a question for Ms. Bosworth, ask the question. If not, she's going to dismiss her and you have no more opportunity to ask her any more questions.
Here's the sketch. I went to alcohol in the health department. Does it show furniture outside the building?
It just says tiki bar.
Okay.
And it is a different sketch than what the ABT sent to us, and the staff,
That's not what I asked you. I asked you if it showed furniture outside the building.
just says tiki bar, doesn't say furniture. And staff would like to say,
Your
also
Honor, can I ask
qualify
the
that
questions
that is
here?
not approval of a site
Can I
plan.
ask the questions here? All I asked her is to confirm the application. Let's coincide what the building director signed off on. He shut down the circular traffic behind my building, gave me a permit. He knew what we were doing. There is an intent here, okay? This was all part of the application. Nothing was being done. The state health department was involved. I mean, the hotels and restaurants, they came out. Alcohol and tobacco came out. They all signed off on it. So let me go back to the questions. I'm going to sidetrack you. Let me just get to my notes. Dory, you've been in the community 27 years, right?
Yes,
How many times do you live in the north, south, east, west? What part of Sebastian do you live in?
I live on the outskirts of the city limits.
To the west, to the north, to the south?
How is that relevant?
Do you pass by our business at all?
Not every day, no, but.
But you do?
But I do I have been there with the city car, and
Okay.
when I travel to Vero, I do.
Yeah, so you've been in I've been there since 92, almost 30 years, right? So is it safe to say in the 90s you drove past that property?
Yes.
Okay.
I have lived here since 1986.
Okay, how about in 2000 through 2010? You drove past that property?
Yes,
Okay. 2010 to 19, you drove by that property?
Yes.
Okay. So it's very evident that the tiki bar is out there with the chairs and the tables 8, 9 years ago. Yes or no?
Yes.
Okay, that's all I need to
But
know.
I believe that there have been previous code
So
enforcement
this
cases
is...
opened against that.
No, well, you'll have to show that in your testimony and your documents. So you knew this was there 8 years ago, correct? You said yes. So my point to you is this was not COVID-related. This was done when Joe Griffin did it 8 years ago. And it was allowed, and it was permitted because I showed the documents to the code enforcement officer, and I'm going to review him because we're going to get him back on the stand. But let me finish my question, because my son's got some questions pertaining to you, because he spoke to you and he handled the application. So we want to clear up a few things. You said that to modify the plans, minor modification to my son, correct?
Correct.
Okay.
And that's what the fee was. for
Okay,
it.
minor modifications. And you came to the property to measure it,
On November 8th,
November 8th. And what exactly did you measure?
we measured parking aisle, drive aisle width, parking width. We measured from the edge of the pavement out into the right-of-way to verify the 10 feet that you were showing. At that site, we were able to see where there are some swale areas. We did, to verify on the site plan, what you had behind the fence. We measured in front of the door. One of your employees did come out. She asked what we were doing. We notified, let her know, and she said, okay.
So you said you went out there to verify the site modification application we sent in, correct?
No, what we were trying to get was dimensions for the site plan.
Did you
so
already
that we-
have the site plan modification sent in to you already? You went after you got the site plan he resubmitted with the check.
Yes.
Okay, to
There
show
was,
where
im-
it's-
yes, there was information that was not on the plan that we needed, and so instead of calling you, we went out and got the measurements ourselves so that we could verify, because this was not a survey.
What
We had no
items
survey.
what items were not on the plan that you needed?
Which was mentioned in our cursory reviews,
Was that sent to us prior to us submitting those plans in your discussion with my son?
August 26th.
Right?
Your son sent me an email with a conceptual plan, with the plan, on August 25th.
How about before that?
No, I didn't see any plan.
Did you discuss what you were looking for in the plans before he submitted the plans? Was there any emails that went back and forth?
Not an email that was done in person when you came in on August 11th.
Do you have notes of that meeting?
Do I have notes?
Yeah, of that meeting when we came in to talk to you and what you were looking for.
No, but I have memory of what we discussed. We discussed what we would need to be able to properly review a site plan.
Which were, well, it was for the tables and the chairs.
We had
What do you recall? Tell us what you recall.
I initially remember saying that this was a very old site plan. We would prefer a survey, that we prefer a new survey, and we usually would get a civil engineered plan that had site plan data. You said that it was going to be a lot of money and that it would take a long time, that everybody was busy. And I said, let me see what we can do, present me something and we can see if it, but I'm going to need different things on it, dimensions, we needed drive aisles, I needed square footage of the
Okay.
parking, excuse me, I'm still finishing, that we needed square footage of the table areas, and I needed capacity for the bar so that we could calculate what parking needs you needed, and then you were going to modify the site to see if you could meet those parking needs.
And you do this for all the businesses in the community. You require them to submit a new survey, up-to-date survey, and an up-to-date site plan. Is that correct?
For properties that have surveys that are 30 to 40 years old, yes. If we have a survey for 10 years, 7 years, if there's a new site plan
Is
that
that
has
in the
correct
code?
data,
Is that in the code, or you decide that?
that is in the code, within a
is-
year. It's supposed to be a survey within a year for a site plan. That is a code in Article 18.
Well, I'm talking about minor modification for furniture. Is that required in the code?
There is-
To have an updated survey to show where your tables and chairs are? If you
So,
can provide a
It
survey
is
that's to scale?
It's a determination of staff that when you put out seating areas and chairs, you are creating seating areas that require parking.
Okay, Your Honor, my son did most of the communications with her, and there's a few things that are not accurate. I'd like for him to call him up to the stand and just verify, because there are some things that, if that's okay with you.
I'm just
Thank you.
confused.
Would you come on up, Damian? Thank you.
If the respondent is calling a different witness, so he's done with Dory, correct?
No,
Your Honor, I'm not a witness. I'm actually signed as I have an affidavit with the city that Dory and I
you
discussed.
would wish to ask this witness some questions based on your experience.
Yes, sir.
So I would like to clarify that, though, that we had talked about getting an affidavit. You never submitted an affidavit. There's no
That's-
affidavit with the application or that you emailed to me.
I have a copy of an affidavit. I can get it out of my email, out of my documents. I did submit an affidavit. It was notarized by Miss Jeanette Williams upstairs. She saw the affidavit when it was notarized, and I did deliver it to the city. Whether or not they disposed of it, I cannot say, but it was delivered. There is an affidavit. I only have a couple of quick questions. I'll be very
Yes,
quick.
if you have questions, that's why you're here, ask questions.
Thank you, Your Honor. Hi, Ms. Bosworth. Thank you for being here today. So in our email, you had said, I'm sorry, in your testimony earlier, you had said something about our motorcycle parking and water issues, stormwater issues. In your email, I don't know if you have a copy of the email in front of you here, you said nothing about stormwater issues. You said you had referenced, could you tell me what you had said in the email, actually?
What I testified was said that I had forwarded you some cursory comments. I said when we went out to the site, we verified that the parking, that motorcycle parking was going to be in some stormwater. That was not determined until we went to the site because your survey didn't have any information on where a swale was or topo information that we could have verified that there was a swale there. But we did determine that when we went out on the site on November 8th. But what I did state about motorcycle parking is that the northeast motorcycle parking area could not be approved as proposed, which was your cursory drawing. There is no direct access to these spaces. Access is either from parking spaces that may have cars parked in them, or you had to go over curb and gutter. No drive-out exists for the access. Same for proposed motorcycle picnic. I said these, and basically I was trying to let you know that where you had them would not work because there was no direct access to those spaces. But you submitted the site plan with those motorcycle spaces in the exact same area.
Now, Ms. Bosworth, if you remember, or maybe you do not, maybe you don't remember, when we came in to speak with you and I asked about proposed motorcycle spaces, do you remember telling me that, because I had inquired about other business locations in the community that I'll leave their name out because we're not here to be picking out anybody else in the community. That's not what we're about.
I told you we talked about Earl's, we talked about Tiki Bar, and
All right,
we talked about Paradolia.
We can name them. So
I'm not trying to hide anything.
I'm not here to pick on any businesses in the community. I think we should all be allowed to have outside tables and we should all be allowed to have motorcycle parking. So when I had mentioned motorcycle parking to you, do you recall telling me that no, we would not be allowed to have motorcycle parking because we are not a motorcycle bar?
No,
Okay,
I remember
'cause that
saying.
was stated.
Because I went in then to tell you that 2 motorcycle parkings would count as 1 space.
Okay. Also, so you had mentioned in your testimony that we do not have access to the proposed parking area without
Correct.
going over a curb or over a gutter
Correct.
or through an existing parking space. When you went out there and you did your survey, were you able to see that you could very clearly access that grass area directly from the driveway itself?
You have no driveway from your driveway. To get to those motorcycle parking, you have to go through the right-of-way grass without a driveway.
One moment, Your Honor.
Sure.
But I'm not sure if we're reviewing the site plan at this point or the fact that it's not approved, and that's why the parking is still not in
On the
conformity.
survey, it shows the driveway where you can get right to the motorcycle parking.
I need the other survey. I need our survey.
She's got it right there. It's in her
You
file.
just turn on that light.
Yeah.
If you want to, just imagine the scene you're looking at. There you go.
Thank you. Your Honor, I have a photo of our driveway that very clearly shows that without going over a gutter, without going through any stormwater issues, that you could absolutely pull motorcycles in and out of this grass parkway, and that this is an example of selective enforcement and selective decision-making upon the city. And we also have a photo of other businesses here in town where you can clearly see that they drive over the sidewalk in order to access their motorcycle parking.
This is a driveway.
So, if I may,
But there's
ma'am,
no-
do you mind? I'm
Well,
asking the questions here.
your
Could you please sit down?
father
Is
came over
this
and
right?
did
Can I
this.
borrow that? I have my own if I can't borrow yours. It's the same.
That's the one in their file. That's the one we're going to use.
Again, Your Honor, if
Thank you.
one person can ask a question and allow the witness time to respond, we're having 3 people talking over each other, and it's going to be really difficult to record what they're saying.
So, Your Honor, I can produce a photo of this, but there's a driveway right here. This is grass
Gilliam?
right here,
Mr.
and
Gilliam,
you can very
Mr. Gilliam,
clearly
sir.
pull-
Hang on.
Mr. Gilliam.
Sorry, First
Mr.
issue
Gilliam.
First. I thought you wanted to introduce some pictures.
Yes, I can show you a picture of it. It's going to take me a moment
Mr.
to pull
Gilliam,
up, if that's all right.
Junior, son, the mic,
Excuse
we
me?
can't hear you.
Thank you. Not a problem.
Thank you.
So,
Yes, Your Honor, just give me one moment. I can pull up
Sure.
a picture of our driveway, but this was right here quickly, so I can show you. I'll show you the picture of the grass that we have. There are about 3 or 4 places right here where you can very immediately access this driveway without issue. There's plenty of parking here that we could have.
Can you give us a moment because we cannot hear you?
Yes, I'm sorry. Here. I have a long enough arm and a pen. I could do it like this. Sure. Can everybody hear me now? All right. So right here you can see on our site plan we showed that we did have motorcycle entrance, right? Do I need to ask these in the form of a question? I can ask Ms. Bosworth.
Yes.
Ms. Bosworth?
First of all, do you plan on introducing pictures?
Yes, Your Honor.
Okay, can we see the pictures?
Yes.
So that the city can say whether they object to the pictures.
Sure. Yes, Your Honor. I'm sorry. Forgive me, I'm not so used to these procedures.
That's fine, that's fine. I have a technical question
Yes.
of the staff.
Sure.
He is accessing pictures on his phone.
Yes.
Do we have the ability to print those from his phone?
If he emails them to mis@cityofsebastian.org, we will verify receipt and get them printed
Okay.
immediately.
Can you do that for me?
Yes, Your Honor.
Appreciate it.
Would you mind writing that email down for me so that I can? Thank you.
They had pictures that they submitted to this morning, earlier.
Yeah, we could use those photos, actually. I'm pretty sure it shows the same thing,
It shows the tables there.
if you may.
Can you get the officers' pictures up? If those will work, then we will use them. This picture?
Nope, nope.
No, Your Honor.
Okay. That picture?
No, Your Honor.
Okay. That one?
That'll work. So if you can see in the distance there, you see.
Hang on.
Oh, yes, Your Honor.
You were asking her questions.
Is that
Ms. Bosworth, do you see where the picnic table is in the distance there?
Yes.
Do you see any curbs or gutters or parking impediments that would allow me to access the spot where that specific picnic table is?
I see posts that are put there to indicate that traffic isn't to go there. I see a picnic bench, but you also can see that there's a swale. You can see how it slopes down. That is part of stormwater. But there's not a driveway from the driveway for that. So you're asking all those motorcycles, how many here? You have all of these, but you need them to go through grass to park.
Okay.
And what are you going to put there? Wheel stops? There has to be some sort of driveway then, some sort of
Ms.
asphalt
Bosworth,
drive aisle. The
please.
code requires drive aisles to access parking lanes.
Ms. Bosworth, my question was just if you can, so
Those are decorative.
those are decorative posts. Those are not,
And
there's no markings on them to indicate
Okay.
that you're not allowed to park through that area. Ms. Bosworth, could you fit a motorcycle through those posts? Yes or no question, please.
Yes,
Yes,
but
you
where's
can.
the
Thank
drive
you.
aisle? You have to have a
So-
paved drive aisle.
Ms. Bosworth, is that not a driveway right there that has no curbs or bumpers on either side of it? Could you drive a motorcycle into that grass area without hitting a bump or a curb? It's a yes or no question, please.
The code requires an asphalted drive aisle to get to those motorcycle paved parcels. Not from here, not off of the road, but from here. Along here is what's required, a paved drive aisle here.
I don't know what you're looking at for the record, because we're looking at a picture. I don't see your fingers. So what are you looking at on the map there?
I'm sorry,
Here we
it's
go.
the,
Here we go. All right.
here it is. We can
Once
read
again-
So
it.
here's the asphalt, you pull in here and you park your motorcycle.
It was her testimony.
Okay.
There is curb and gutter here, and that is where, so you can't go from here, so you're going to have to go from here, and that's where you have your arrow. This has to be this has to be a paved drive aisle. But I'm not sure, the gist of this question is that I admit that this site plan has not been all the way reviewed, and it has not been stamped off.
Ms. Bosworth.
And we seem to be arguing what the
My
site plan
question
is.
was only, could you fit a motorcycle through those posts?
Are we
Yes or
reviewing
no?
the site plan? Is that the
No, ma'am,
matter of these questions?
I'm simply asking you if I could fit a motorcycle through those posts.
Yes, through the
Okay, thank you.
post.
So, I have another photo I'd like to submit into evidence.
Sure.
And would you like me to show who first? I'm sorry?
Please.
Would you like me to describe it first?
No.
Yeah.
Okay.
Hand it to the city attorney.
What is this? I'm sorry. I have the objection, and apparently it's a picture of Earl's, I think.
Okay. All right, so this is Earl's Hideaway. All right. Okay.
Yes, thank you.
And they showed on the site plan, we have the site plan to back that up too.
Okay.
but it's not accurate as far as, so.
Now, like I said, we're not here to pick on anybody in this community. We think that Earls should be allowed to have this parking.
In fact, they do.
And in fact, they do. So
On an
I just
approved
want
site
to,
plan.
ma'am, please. So if I could, ma'am, are you familiar with this picture of this location?
Yes.
Can you tell me how you can get a motorcycle into that parking spot without going over a curb or gutter or a sidewalk?
It's on an approved site plan. That's not to say that they don't go over that thing, but there is entrance right here.
Yeah, we're still, for the record, we're still looking at the pictures, so you said right here. Can we
I'm sorry, we
do that
pull it
again?
over for you, Your
We're
Honor.
going to tie it together with the site plan now.
Right, well, just for the record, we need to, here we go.
Ms. Bosworth, is this the exact same thing that we're looking at here? Are we looking at a picture of this location here?
Yes.
Okay. Can you tell me how many motorcycle spots they have there?
I have not reviewed this offhand and counting, and I'm sure there's a calculation on a brand-new site plan that's older than, it's more recent than 40 years old.
I'm sorry, Ms. Bosworth, that wasn't my question, but this is a recent site plan of Earl's,
Yes.
correct?
Well, the
And then
last approved
there's-
site plan.
25, I think. Go ahead, count.
$25 parking spots are there.
And then on the river, I'll show on the.
Well, hold on, one moment.
You gotta go over
So-
you gotta go over the sidewalk to get to those as well, safety issues.
So, let me ask you, do pedestrians use this sidewalk?
Yes.
Do they have a crossing guard that allows people to pull their motorcycles in to prevent people in the driveway here?
Per their site plan, they are supposed to enter this from the Earl's driveway. There is, if an officer saw them cross over this, they certainly could give them a ticket. They are to enter from here. That is.
Ms. Bosworth, can you point to me on here where it shows that driveway aisle?
Can we let her finish her answer? The
Did you
enter
finish
through
your
where?
answer?
I'm sorry, did you finish your answer? I didn't mean to interrupt.
Based on the, you can tell based on the angle of those parking spaces, that entrance would be here, and you park there, like that.
Are there signs posted
And there's
there?
also landscaping here. There's a landscape buffer here that would certainly, the intent was not to be able to drive over the sidewalk to get to those spaces. There's landscaping here, there's hedging, there's this. So that was the intent of you came in here, and you came here to use those parking spaces. It was never intended to go over the US 1 sidewalk.
Yeah, where's the
That's
pavement?
FDOT.
Where's the driveway?
Can you show where the pavement for those motorcycles are? That you're saying that we would have to put down pavement for our motorcycle stops. Can you show where they are in this picture? Where the motorcycles
I
are?
haven't sent you formal site plan review yet.
No,
on
you
your
haven't,
site
and
plan.
actually, that was the first that we had heard of it today, that we would need to put down cement of any sort, and, Your Honor, I think it's pretty...
We didn't say that you had to put cement down.
Ma'am, please.
Doris, you can sit
I think
down.
it's a little bit much to us to ask for us to go ahead and put down cement or gravel before something
I
has been approved.
assume there's no more questions for Ms. Bosworth?
No, I'm not quite done, but thank you.
Okay, well then, save your arguments for the end and ask questions, please.
Ms. Bosworth, are you saying that the entrance for these motorcycles is between where the Earl's Hideaway sign and what looks like a Chevy SUV? Is that the entrance right there?
I don't,
The
yes.
first SUV there?
Per the approved site plan, yes.
Do you see the motorcycle parked there next to the third tree? Can you say what direction that is? Does it look like they pulled in through that drive aisle?
The city did not approve how they pulled into that parking space.
Okay. Is the city aware that there are businesses in the community that are pulling over sidewalks?
I believe that that possibly would be a police matter, that if they saw it, they certainly could give a ticket to those motorcycle drivers that are illegally parked.
Has code enforcement been by to ask them any questions about that you're aware of?
That would, if so chosen, if it became an issue, a problem, if there was enough citations, the code enforcement through and planning and zoning could issue them a violation of site plan compliance, yes.
And if also, based on the new statute, if the no name bar and the respondents wants to file a complaint against Earls, then they can file the appropriate application.
We have no interest in doing that,
And we will look
Your
into that.
Honor.
We cannot do anonymous complaints anymore.
We have absolutely no interest in filing any complaints against Earl's Hideaway or their customers that are parking whatsoever. We just want to point out that if you look at our picture here of, if you can, I'm sorry, Miss, if you could please go back to our photo of our driveway that we had posted.
Any more questions for
Yes,
Ms.
I'm not quite
Bosworth?
done. Mr. Anon, I'll let you know when I'm done. Thank you.
The issue is, Mr.
Is this the right picture you wanted up?
Gail, yes.
Yeah, they took the one we sent them, they took it back, so we got a copy that we submitted.
That's right. Right, give me one.
Quick question, while he's doing that. You mentioned something about stormwater. Back in 1975, there was no stormwater required. There's nothing on there, so you're creating something that's not there. Would you agree?
No,
Okay, so where did you find the stormwater in the file, the city files that we have?
not the file,
storm-
but you can clearly see on site that that is a conveyance swale.
Gotcha.
You have no stormwater on your site, so water from your parking lot
So this-
is probably
this-
going to this area, and there is a catch basin to the east of that
So,
swale.
but just for the record, you have nothing on file that shows that that property, when it was developed, relates to stormwater in that area. Is that correct?
But I wasn't going to ask you to put in some additional
Okay, but I just
stormwater.
want to get the record clear that back in 1975, when this building was built and the parking was done, there was no stormwater depicted in that paperwork. Is that correct? You have the file, I have the file too.
From the 1992 survey that is in your file, there is no stormwater swale area.
Thank you.
There's no stormwater area.
So, thank you. That was my point, that there's no stormwater in that area where we're going to put motorcycles.
As depicted
For
on the
additional,
survey.
for additional parking to appease the city. All right?
I'd like to clarify the difference
Do
between a
you or your
survey
son
and
have
a
any more
site plan.
questions?
Your Honor, I can't hear you, I'm sorry.
Do you or your son have any more questions of the witness?
Yes, we have more
The
questions.
witness is requested to complete her answer. Go ahead.
Go ahead, Damon.
I'm sorry.
You have requested to complete your answer.
Oh, there is a difference between a survey, a boundary survey that just shows boundary and the building location, which is all that 1992 survey does. A site plan will give you more of your topographical information and your stormwater areas. And I have not seen a St. John's permit for this. We didn't look for it. But to use the survey to say that that doesn't show, it usually doesn't. A boundary survey usually doesn't show stormwater areas.
Right, so anything that's new in the city that people come in and park, that's new, recent, right? You say how far back? You required St. John's, how far back do you go?
I said I had not looked at the St. John's permit for this
But
site.
how far
if
back
there
did
was one.
how far back was it that they required stormwater and?
I have no idea. That's St. John's. That'd be a question for St.
How
John's.
about the city of Sebastian? How far back does the city require stormwater?
So our land development code was
Yes.
formally established in 1985, and that site plan section requires stormwater permits.
So it's safe to say that anything in 2025,
I
2015?
can't speak for when St. John was established and when they were
No,
requiring
no,
stormwater
not talking about, I'm
permits.
talking about the city of Sebastian. In your site plan process, in your land development code, you require stormwater, landscaping, et cetera, correct? For when you have property that's being utilized?
Correct, and that would be
Okay.
before 1985 also.
Right, so anything 1990, 2000, 2010, safe to say that there was, in the site plans, it was required to have stormwater, right?
Correct,
Okay. And parking and curb gutters and all that, to get access, right?
yes.
Okay, all right. So I'm going to let him finish his line of thing, and then I'm going to bring up another piece of property in the community to show you inconsistency and how you're being selective in your code enforcement. Go ahead. Go ahead, Damien.
If you don't mind, I need to project right here. Thank you. Ms. Bosworth, is it your testimony today that with this motorcycle entrance here and our proposed motorcycle parking, that we could not also accomplish the same thing as another local prospering business?
How I'm going to respond is that there's a reason that you do not have formal site plan comments yet from staff, because your site plan has not been formally and completely finished of a review. We had to go out to get all of the dimensions that were not on the site plan for us to complete our site plan, so I am not going to respond to possible comments that may or may not be in your final comment, site plan comment review.
Was it your testimony earlier that we had not addressed any of the points that you had emailed to us? It's a yes or no question.
I'm reviewing the comments, sir.
That's fine.
We had talked about the motorcycle, that we said we could not drive over grass areas. We said that we needed a scaled floor plan. We also said that the plan shows outside storage area, which had not had some previous approval. We talked about drive aisle width, and I said that we needed dimensions, and pavement marking should be necessary and shown on the plan. So there were things on that cursory review comment that we did not get on the formal submittal.
Were any of those addressed when the formal submittal was sent in?
I don't know, because we haven't finished our review.
Okay.
Getting back to your cell phone, do you wish to introduce those pictures that are on your cell phone?
No, Your Honor, it was almost essentially the same photo here. Almost,
Okay.
It's almost the same picture. I just wanted to show that there's plenty of room here where you could fit multiple motorcycles through this here, where you have a driveway aisle that you can immediately access it, accessing this with a motorcycle, and however we would decide to put down asphalt, gravel, pavers to accommodate our motorcycle guests. And I can also supply other photos where we do have plenty of motorcyclists that come to our establishment.
Yeah, we have.
And
We've
got a photo that'll show our whole parking lot filled with motorcycles. We do have motorcycles that come to our establishment, and we would like to update our parking to allow them to have a space where they can park, you know, rather than just taking up a couple of parking spots, which we think will actually improve the safety on our property.
Do you have any more questions of the witness?
Yes, Your Honor.
Thank you for your patience through all these questions.
No patience needed. You're fine.
Mrs. Bodge, you familiar with that picture?
Yes.
Okay. Are you familiar with their site plan?
To a T.
To a T? Okay.
Just for clarity's sake,
Just for the
those of
record,
us
because
who are
I'm not familiar
the
with what we're
picture,
looking at.
This is a site plan on Indian River Drive that has improvements, that has vehicles that drive over the sidewalk. And again, we don't have any issues with these people. Just don't.
This
But
is from another establishment?
this is in our district, the CRA. And this piece of property has a major improvement where you can see the vehicles every day, and there's improvements on the uplands, not just out in the river and the dock and the slips. They're operating, whether it's profitable, non-profit. I didn't want to get into that. My point here, Your Honor, is this is what we call selective enforcement in the town of Sebastian. This here is where, talk about safety issues. And everybody knows, but everybody's afraid to bring this up because the individual.
Your Honor, if I can, is there a question for Ms. Bosworth, or he wants to make closing arguments?
So I want to show you a site plan that I have.
Then
right
ask the
here.
We can ask the
question,
questions.
or save it for your summation.
Okay.
Sorry,
so
we were trying to explain
I
what
wanted
the
to make
picture
sure
was.
she's familiar with the property.
I
So
don't
you
even know
are.
what we're looking at.
Okay.
Well, that's why we were trying to explain it to you.
We requested an updated, most recent site plan for that particular property.
What establishment are we talking
We're
about?
talking about the address on it. It's a,
Is that Sembler's property?
It's
So you are
1520
familiar with
it's
it?
1528 Indian
Because
River Drive.
I see the big statue.
Yes, it's the property that
symbol.
has all of the statutes, the
Got it.
art.
I
It's
know where we're
very
at.
great art. We love the property. We really do. And
think
we
it's-
know the people that work there as well, and they're great. So,
Yeah, so.
I know where it's
so
at now.
So, Mrs. Dahl, you're familiar with this, right?
Yes.
Okay, and they have a completed site plan showing their drainage, retention, stormwater, permit access. Do they have all of that in their file?
So you
That's
requested.
a yes, no.
You requested this information the other day, and we sent you. This is, the approved site plan is their submerged land lease. This is an agricultural piece of property.
That's not what I'm asking.
They
I'm
don't.
asking, is there parking?
Let the witness
Is there
answer the
parking on
question,
this
Your
site
Honor. It's not
plan
a yes or
to
no
utilize
answer.
that property?
It was not required.
Not required.
Correct.
So why are there trucks driving over the sidewalk?
Those are the trucks that are doing the aquaculture. They are clamming. They have their site plan is their submerged land lease. They received 2 building permits for their deck and their dock, which were the principal use of that property is the aquaculture.
We know what-
That is. So there is no public
So
access to this property.
there's an exemption in your land
Let her
development code that
answer,
when you
Your
do
Honor.
an
Your
improvement,
Honor.
Hang on for a sec. Hang
Let
on.
her answer.
there's an exemption in
Hang
your
on,
land.
hang-
Your
Oh, I'm sorry.
Honor, let her
Were you able to
answer.
finish your answer?
Finish your
There's
answer,
no
Dory.
exemption needed because the site is not supposed to be accessed by the public. I cannot verify if those cars in there are for the workers that are doing the clamming. There is no necessary need for the public to access a clamming aquaculture that is in the water. And that clamming is the clamming aquaculture business is monitored by the state as their submerged land lease, is their site plan. There was no site plan for the city. What you are again looking at is a survey, which is not a site plan. It's a survey, which is a boundary survey that shows easements and dimensions. That's why there is no survey for that property. There is no site plan for that property because there isn't a site plan for the city that's needed. Their site plan is the submerged land lease, which is through the state of Florida.
Ms. Bosworth, can you tell us how these vehicles access their parking?
I do not know how they access that, but it's for the people that own that for the submerged land lease.
We're not getting into
I didn't ask who it was for. Are you aware that they drive over the sidewalk in order to access that property?
I do not know if they access from the Fisherman's Landing site or if they go through there.
Is there access from Fisherman's Landing site where you can drive over to their property, or is it fenced off?
I don't have the site plan in front of me, so I do not know. And I did not process that site plan. So I'm not familiar with that site plan.
Do you see the date on this survey?
Yes,
What's the date say?
it's probably a current one. But you don't have the,
Yeah, I have it right here in front of me. Do you want me to show it to you? Yeah.
(2007)
yes. And I do not know if that's the last site plan that we had. That's what you requested.
That's not a site plan, you said, that's
A
a survey.
You requested the most current survey that we had. That's what we had in the
They
file.
don't have a site plan.
Correct.
Yeah, so they have property that they're utilizing in the city. Land Development Code does not, they have an exemption because they have a submerged land lease. Excuse me.
It's not
Stop.
offered to the public.
Stop. I own 2 marinas in this town. I'm very familiar with submerged land leases, ma'am, and the state, okay? There is no exemption in your Land Development Code that excuses you from putting in a cut into to get into that property, access that property, you must have a permit, driveway permit. There is none. We all know that, and we understand that there is no drainage, there is no parking, there is nothing there, but whether it's submerged land lease, it's nonprofit, for-profit, is all irrelevant. It's a piece of property within the city of Sebastian that they get to utilize. People drive on there, take pictures of all the improvements, the artwork, and they're creating a hazard. But
Again, is there a
nobody
question,
turns
Your
them
Honor?
in. So are you familiar with any of your code violations? Or maybe I'll save that for Kirk. Let me save that for Kirk, because you've already answered the questions on the site plan, which is your profession.
Which I would like to state as final, is that is not a site plan for public
Survey.
access.
Survey.
Only the private property owner to get to his aquaculture facility.
Okay, so,
Ms. Bosworth, is it safe to say that tourists stop by this location because of the beautiful art that they have there?
Yes.
Yeah, is it safe to say that it's one of the major attractions in town?
I don't know if they're accessing from the sidewalk or if those are their cars driving. I do not know if those are tourist cars or if those are the workers that are there for the clamming business. Do you know?
Yes. I've lived in this community long enough, I've walked on that sidewalk long enough to know that I've seen plenty of person that were not working there drive up that driveway, drive over the sidewalk through the right-of-way in order to park their vehicles and take pictures with the signs, which, once again, I'm not opposed to. As long as they don't run anybody over, you can hop over the sidewalk, although it does destroy our sidewalks and then we have to go replace them.
There's no outside seating there, though. There's no outside seating there.
No, but we're talking about parking. And the public, the general public does use that
sake of time,
parking.
let's move forward. You can identify this piece of property, I'm sure you can. Can you tell us who owns this piece of property right here, Mrs. Bosworth? It says it got a sign right in front of it. Can you tell the community who owns that?
City of Sebastian,
The city of Sebastian owns that.
yes.
Oh, okay. Here's a blown-up shot with tables outside.
Yes.
Did they
In the walkway.
In the walkway. Did they submit a modification to your department? Yes or no?
They are under an emergency order because of the
Okay.
structural building.
Ms. Bosworth.
Yes or no question.
Yes, did they submit a modification for that have tables outside and chairs outside for the restaurant to utilize it. Did they submit a
They
modification?
have city
Hold on,
council
Dory.
approval,
Hold
and
on,
they are
Dory.
under an emergency order for the structural of the building.
Okay, so it's safe to say that they did not submit, the city did not submit a site plan modification, even a survey modification, okay? Because we have your paperwork here, okay? So it's safe to say that the city's operating under emergency order. Is that what you just said?
If you had an emergency order placed on your building, we would not require you to do a site plan to move your tables temporarily outside until those
You're
issues
right.
were corrected.
COVID-19 is not an emergency order from the governor. You're
Your
right. Now
Honor,
let me move forward.
if I can, I assume what we're looking at is crabby bills. This was public last council meeting, so I can discuss it. This is a pressing issue where the building itself is,
Your Honor,
has issues.
we're not questioning the city attorney.
I'm going to answer the question now, because that's why tables are outside. It's not COVID related. This is an emergency because we had a structural engineer that did an evaluation of the building, and certain parts of it was considered to be critical. So those parts were sectioned off. And this is part of the agreement that we're working with them, and we're still not done, was moving some of the stuff, because we actually had the building person come in there and shut the building down temporarily.
So look, the question I have here, Your Honor.
Hang on for a second. So are you objecting to this line of question because it is not germane?
It's extremely not germane. None of these cases are really germane because all these properties have proper site plans been approved. All we're asking them is to go through the process temporarily, move these tables out of the way, go through the process. We have no problem, like, I don't know his first name, but Gilliam Jr. was stating,
Damien.
we have no problem them having bars, motorcycle places and stuff, as long as they go through the process like everyone else has gone through. That's it.
Ms. Bosworth, is it standard procedure that you do not hear anything back for over 3 months after supplying an application for a minor site plan update?
It's
3 months?
currently, yes, just like it's so hard to get a civil engineer and a surveyor right now, everybody is overloaded, it is behind.
What is the code requirement to get back to an applicant? You must have some
There
sort
is
of...
no code requirement in our
There's
code.
no timeline to get back to an
No,
applicant?
there are state statutes to try and follow, but
So you're backed up.
we have tried to do is 30 days has been our guideline, but none of
okay.
the site plans have been able to.
Let me move on the questioning here. So this is really, the city owns the property, but there's a private business for profit that has those tables that they're utilizing. Is that correct?
It is a sublease as part of our.
I said that.
As part of our Florida Communities Trust, we are required to have a museum
Is it
and
a
a
for-profit?
fish eatery
Your Honor, I
there.
object to any of these
Is it
line
a
of questions. It's
for-profit
not
business?
relevant
Is it
to their
for-profit
site
business?
plans.
Yes or no? Just like our business, is it for profit?
Yes,
That's all I need to know. That's all I'm asking. So it's a for-profit business utilizing tables outside without a modification application. That's all we're getting to here. Okay, let me move on. I don't need to, unless you have something on this, Steve, no? Okay.
Again, Your Honor, just my objection what's going on with Crappy Bills is extremely to the extreme of what's going on here. They don't have an emergency situation. We're not shutting down their building. We're not asking them, hey, move your tables outside to facilitate you temporarily. There is a tenant there. It's a completely different situation, extremely not germane to their case.
Any more questions
Yeah,
for the
I'm
witness?
checking my notes for Mrs. Bosworth. Okay, great. I'm glad you made that note that you're willing to work with us on the modification that we...
It's the first we've heard of it.
Yeah.
Of course we
Okay.
are, as long as you move your tables out, and we've said that from the beginning.
so-
We've been saying it from the beginning that are you willing to move their tables out? We'll give you time
Well, they're not-
to get the site plan approved.
The code that you cited pertaining to COVID-19 does not pertain because we've submitted evidence showing that the director of community development back 8 years ago approved our furniture outside, 8 years ago. So the record is very clear with the state, hotels and restaurants, and
If
it's
we're
been going on
arguing,
for
Your Honor,
8 years.
Okay, I'm gonna let him state his position, but if we're gonna
Do you have
argue,
any more questions of the witness?
yes, because
I
if we're gonna
have-
argue, we emphatically disagree. That was an alcohol and tobacco application, which the testimony was clear, it had nothing to do with the site plan, it had to do with them specifically going. And then now I'm questioning whether or not we have the official file from ABT, and I will follow up tomorrow asking them what is the official file, because apparently now there seems to be a difference in what we received from them and what now they're submitting today.
Can you
But
show
it
us
has
the
nothing
copy
to
that
do
you
with it,
have?
Your Honor.
Dory?
I did
If I
show it.
can,
It is
if I
different.
can.
Yeah, just
if
show
I
us the copy
can.
one more time
He
for the
made-
record.
He made an argument, and I apologize. He made the argument, and I'm counting the argument, since apparently we're not taking testimony.
Well, I've asked this question twice, and I've yet to get an answer. Do you have any more questions of the witness?
Yes, Your Honor.
Okay, let's stick to the questions for this witness.
Ms. Bosworth, is it standard practice when you submit an update or a modification with a code enforcement violation that you are in compliance as the modification is going through?
So the normal
It
procedure.
was a yes or no question. I'm sorry, Ms. Bosworth. Just
They're
yes
not
or no.
always- they're not
If you
always clear
can't
as yes
answer
and no.
yes, Dory, hold on. If you can't answer yes or no, answer. If not, tell the magistrate that it's not a yes or no answer, and then allow him rule on it.
It's not a yes or no answer.
Why?
Your question was, is through code enforcement, could you repeat the question?
Yes. Through code enforcement, when there's a violation and you attempt to fix that violation and you're working with the city, aren't you in compliance while it's going through to submit a plan?
No. You're in
Is that
compliance when it's
opposite, ma'am?
stamped.
Is that what you had told me when we came into the office?
I am, and I am sworn in, I am positive that I told you that submittal of the site plan does not make your nonconformity and your code enforcement case go away.
Okay, we'll touch base on that later with Kurt.
Okay, I think,
That's all of my questions, Your Honor. Thank you for your time.
Okay.
yeah, I think that,
City, any redirect?
I think I made the argument, but I'm going to go ahead and get it through testimony. The plans or the pictures, for lack of a better word, just to be clear, I thought it was Earl and Sembler. Those have approved site plans, correct?
They have approved site plans, and
you
they
just said
did,
they didn't. Semblance doesn't have a site plan, they got a survey.
they have a submerged land lease, which is their site plan through the state of Florida, not through the city of
We're
Sebastian.
talking about the uplands.
Does Earl, let's take one at a time. Does Earl have, the pictures, does Earl have a legal site plan for their motorcycle parkings?
Yes.
Okay. And I think you testified that Sembler has what?
Semblers does not have a site plan through the city, it is through the state of Florida for a submerged land lease.
But you testified that the purpose for those cars, you believe, because you don't know, was for the aquatic purposes?
The access to the property is not open to the public, it is for the workers of the clamming operation. I cannot verify the pictures of who owned those cars.
Okay, all right. And currently, right now, since this is what we're here for today, the no-name barred and the respondents do not have an approved site plan, correct?
As determined by staff and what we feel is in the file and what has been submitted, nothing has been stamped off as formally approved for outside seating areas.
That's it.
Can we just see one more time the document that shows the sketch for Joe that signed off for alcohol and tobacco? Can you show that?
If I can put it on under there, if you're asking to see it.
I'd like to review the document and
So this is
And
recross?
I assume for the record, this is the, when we contacted them directly, this is what we got from alcohol and tobacco.
so let's go
So-
through. Can I ask the questions on the document, please? I'm asking the questions.
Well, we can't see it.
Okay. So, is that the document that goes to the alcohol and tobacco and hotels and restaurants?
This was requested from the Division of Alcohol, Beverages, and Tobacco on May 9th, 2017. This came from the lady that worked there. This is what she had on file. Page
Can we-
1. Page 2 does not have this signed off on, but there is Joe Griffin's signature. There are some other signatures. This came from them over fax. what is in dispute or what we feel has been changed.
Stop right there. Let me
Okay.
ask, can I ask the questions now? This is the application you got from the state, correct?
Yes,
Okay.
Can you guys lift it? There you
Okay.
go.
yeah.
Does the application show furniture outside?
It just says Tiki and Tiki Bar.
Gotcha. So.
And
Oh, wait a minute.
if I may clarify, in 2013, there was a fence permit that was put in here for out, but it doesn't show this, and this was from 2017.
Didn't that,
So it didn't show the
alcohol,
fence.
tobacco, and hotels and restaurants don't require fence permits. Let me just for the record, so Your Honor sees that back in 2013, she got this document from the state. This is her paperwork, reflecting furniture outside in the yard.
If I
Back,
could-
can I?
I just wanted to clarify with what you just said. They received this in 2013. We requested it in 2017.
Okay, let's go to the other document you got right there. Yeah, no, the other document.
Well, I
That's
wanted.
it's the
but-
same one.
But what we received from ABT was not only this, but also this page. And we circled, it says Tiki Bar, it says grass area, and there's a Tiki Bar here.
Correct.
That is what came from ABT.
Correct. And that's what the application, can I see, yeah. So,
Yes.
so you're making it very clear that there was furniture that was permitted since 2013.
It does not say
Right.
picnic tables, it does not say chairs, it does not
I'm
say
not
all that,
getting-
it just says a Tiki Bar.
Okay, I'm
Which would
just
be a
get-
Tiki Bar with maybe 3 or 4 chairs around.
But I'm not going to get into the splitting hairs, Your Honor. I'm just saying, I'm trying to make a point that we shut down, and I'll show you our drawings, we shut down 5 tables inside of our business to bring tables outside back then. And they have a copy in the file, okay? And I just want to show the public and show you that this was done back in 2013. Then they reviewed it again when they did the fence permit, 2017. I mean, they knew this. This is nothing new. The code enforcement knew that we were doing this. Everybody was injured until the recall and politics got involved. So go ahead. So it's fair to say that we'll allow furniture outside as far as
So-
a tiki bar with chairs, right?
This was done in 2013. In 2017, more chairs and everything were added. You were trying to present to Mr. Griffin that he had already signed off on that. He asked you for a copy of this. This is what you brought to Mr. Griffin in 2017, trying to show that you had been approved for that. That last document has been altered. It says Tiki Bar and tables and chairs. It says Tiki Bar, tables and chairs. That was not on the document that was given to ABT.
Go back to the other document. Can I go through this, please? This is your document.
No, this is what we received from ABT.
Okay, that's the one that's the one that says, all I'm trying to make is a point that back then, we were allowed stools, chairs, tiki bar serving outside. That's my point. Here you go. I don't need any more. Thank you. That's my point I wanted to make to Your Honor.
Any more questions of the witness?
No, I think that, no, we're done with Mrs. Boswell. Thank you, Mrs. Boswell. Sorry that took so long.
Any further questions of the witness?
I'd like to call back Kurt.
Hang on for a sec.
Okay.
All right, so, any more witnesses for the city?
Just 2 witnesses, but Mr. Curtis was proffered earlier. Why didn't he call back again? You should ask questions earlier. I mean, Mr. Curtis was proffered earlier. I'm not sure why he's being brought back again. I'll object to any question, Mr. Curtis, at this time.
So you wish to have the officer testify
Yeah, he
as
stepped
a
away.
witness for you?
He stepped away to your documents, and I want to, we took a break and said we'll go with the other witnesses.
So I just want to understand the procedure. Are you asking him to come back for cross-examination, or are you wishing to present him as a witness in your case?
Cross-examination from the previous time.
Okay, so you wish to continue your cross-examination?
Yes, sir.
Okay, proceed.
So, Kurt, you gave me some paperwork that reflects the documents you wanted to submit into evidence. And these are the call logs that I'm going to ask you a few questions on, okay?
Okay.
So, on the call log in August, it says, time received August 10th, 2021. There was a call for you to come out to our property to do a written warning. Do you want me to show you that?
I think I have it. What date was that? What date was that?
August 10th?
Okay, 10th. Actually, got the wrong documents here. Apparently, I don't have that. Let me see that.
Sure.
Okay. Okay, yeah.
You just gave me that?
Yeah.
You want this? Okay. So you got the call and you came down, and it says here,
Could you address the officer's questions by putting it under the,
Yeah, I could do that, sure, if they want to show it, absolutely. Thank you, Your Honor.
Okay.
So, on here it says you came down to give us a written warning on that day, August 10th, 2021. It says
Yes,
written
yes,
warning given.
yes.
Okay. And who sends you out on this? Dispatch sends you out?
Dispatch. No, this was a follow-up from the community development letter we received on dated July 1st, that explained that, the emergency COVID policies were lifted, and so we had to resort back to that letter. So this was a follow-up to that. You had 31 days when I gave you that letter on the 9th.
Okay. Well, you came out on the 10th. And you came out, you gave us a written warning.
Correct.
And you said that was initiated by the Community Development Director. What's her name?
That's actually, I dealt with Dory.
Oh, you did?
Bosworth.
Okay,
Yeah,
so
I
it
dealt with
wasn't the
Dory.
director, it was,
I dealt with Dory.
gotcha, okay. And were you ever out to the property before this?
Yes.
Okay.
Before the 10th?
Yes.
Yes,
yeah,
yes,
Yeah.
yes.
You came out numerous times to this property over the years. You came out because we have you when you came to the property back in 17, and they were questioning us, and we showed you the documents, is that correct?
17. I believe you showed me some documents. I believe that, yes.
Okay,
I
thank
kind
you.
of remember that, yes.
Okay, thank you. So this was an issue back in 2017, not just creeping up 2021 for COVID-19. Did you ever follow up back in 2017 when we had our documents? I gave them to you. I showed you that we're within the code. Was there ever a follow-up, or was there ever charges brought to our attention?
Well, actually, you followed up with the city manager, and the city manager can do that. It was out of my hands at that point.
I understand it, but there was never any code violation that was written up. There's never any warning back in 2017, correct? Is it in your file?
I don't know. I don't recall.
Well, you do have your file with you, right?
Not with me right now. You're talking about some from 2017. I wouldn't have that with me.
But you just said you did remember coming out and talking to us
I
about it,
do remember
and
that.
me giving
I
you the
remember
documents,
that.
and
You showed me a doc. Yes, you did.
Okay.
I remember
All right.
that. I remember that.
So it's established that this has been going on since 2017, and you never wrote us a warning to come in front of this magistrate back in 2017. Is that correct?
I don't know. Let's say I don't.
Well,
I'm not sure about that.
Do you ever recall testifying back in 2017?
No, well, I didn't testify. Doesn't mean I didn't write you to come to the magistrate.
Okay. All right. So back in, on this call here,
Yes.
so it was Dory that sent this out, correct? For code violations?
No. It came from her department.
department,
All I'm
sure.
saying is I was dealing with Dory.
Okay. Are you familiar with the new law that the governor put into place about code violations and reporting them?
About the anonymous, you can no longer be anonymous? Is that what you're talking about?
Right.
Yes.
So this was, and you said you spoke to Dory. This was initiated by the city, correct? You said that.
No. Wait a minute. No.
Okay.
I don't know who initiated this. When I got involved, it came through the Community Development Department.
Okay. Because just a minute ago, we can play the tape back, it's recorded. You said it initiated with Dory and the...
No, I said I dealt with Dory.
Okay, all right. So, did she ever tell you that it was a private citizen that initiated this?
I don't inquire who complains. I do not. I will only probably inquire. Actually, I would know if they complain to me directly, but I don't usually inquire who complains.
Let me share this with you and see if you're familiar with this new law. This was back before you came out to the property. This is in June.
Right.
Ron DeSantis signed the Senate Bill 60 into law, which no longer allows code enforcement officers to investigate anonymous complaints. All code enforcement reports must include the complaint's personal information, including name and address. So there was no personal individual that did this. This was the city that initiated it, correct?
Well, I wouldn't say that. I mean, it's obvious. This was, you just asked me, you said, since 2017,
Well, if you-
this was an issue with your, hold on, let me finish.
All right.
You said it's an issue with your property, so you knew this from 2017. Whatever the city manager did in 2017 has nothing to do with me. But this is something that is enforceable. We don't need a complaint. This is something I can clearly see. And so when it was brought to me that you do not have an approved site plan for these tables and chairs, I enforced it. We don't need an anonymous complaint. We don't take anonymous complaints anymore. And so I wouldn't need a complaint for something that's, that's out in the open. That's a violation.
So it basically says here that a person designated as the code inspector may not initiate an investigation of a potential violation of duly enacted code or ordinance by way of an anonymous complaint. So it was really the city that filed the complaint, because you would have to have in your file that person that filed the complaint, and you don't have that with you today, correct?
When I got involved, Mr. Gilliam.
I'm just asking you, you're
I
looking at
can't,
file,
that-
do you have the person that filed the complaint?
That question is not a valid question. Because I explained how I came about getting involved, and this was a known problem with your property you just asked me that, from 2017. And so we wouldn't need a complaint from someone outside to enforce this. You got a reprieve. I'm guessing from your responses that the city manager somehow, I was not involved in that, but I knew there was an issue which I was seeing from back then.
It says that there's one exception to this law, and it's outlined in there, that the person designated as the code inspector has reason to believe that the violation presents an imminent threat to the public health, safety, and welfare. Is there an imminent threat with our tables to the health, welfare of the public?
Based on Ms. Bosworth's testimony, potentially your customers could get injured, I guess, if the chairs are in the walkway or the driveway. I'm just going by what the testimony she gave.
Mm-hmm. Did you see traffic cones out there?
At your property?
Yeah.
I don't recall. I might have seen. I don't recall.
You don't recall?
Actually, I don't. Is there one in the pictures that I've taken? There might be. You might have a cone. I think so. Don't forget I deal with a lot of.
multiple cones. No,
I deal with a lot of properties, so it's hard to.
We can refresh your memory.
Okay. I think. Yeah.
Okay. So there's not a health and safety issue there. That was my
Okay.
point. Okay. So
Actually, there's a cone right there.
yeah, that's right. It's right there for you.
Yeah.
Okay.
Hi, Mr. Bloomfield.
How are you?
Doing great. So one of these times that you had come out, you had expressed to us that this area here, I'm sorry, could we get this picture that we have here up on the screen for everyone? Yes, thank you. You had expressed to me that this drive aisle here, which is between the picnic table and the building itself, could be a potential threat, because we did previously have tables in that area. You remember those tables that were over there?
I believe so. Yes.
After you had came out and you had expressed that that was a potential safety hazard, you can see here in this picture that those tables were moved out of the way of the drive aisle, correct?
I would agree. Yes.
Okay, so these cones here are off to the left, and there are some cones as well you can't see. They're off to the right of the tiki bar here. There's cones and planters over there as well, to designate that this is a walking area back and forth between our outside seating, so that vehicles can pull through here if they need to. That was rectified after you came out and you asked us to fix that, wasn't it? As seen in this picture?
Yes.
Okay, thank you.
Oh, here they go, I got them. So we had put up some other pictures in the community, and I can refresh your memory. Like this way, we didn't put that one up yet. Oh, here we go. You are a certified code enforcement officer, is that correct?
Yes, I am.
You are. Can you tell us your qualifications?
Well, I'm certified as code enforcement officer in level 1 and level 2, which is what, and actually level 3, which is what the city requires. So I'm certified to enforce codes, city ordinances, statute, or Florida statute.
So you have additional education in code enforcement, and when you see a violation, you can identify a violation?
I can, yes.
Okay.
Most times, yes.
Okay. If we can get the, okay.
Again, Your Honor, I'm going to object to these line of questionings. This is a approved site plan, and it's not germane to this case.
How is this germane, over and above what else you've explored at this site?
Well, he's a professional witness, an expert, and I wanted to show him, see if there's a safety, health, and hazard issue right here, and can these bikes get in and out? Is there an egress and ingress getting out to the driveway?
So is the purpose for this questioning to see if we are within the realm of the exception that you pointed out?
Correct.
Any argument regarding whether the exception applies?
Again, Your Honor, my objection is it's not germane. We're talking about a site plan review, and this plan has already been reviewed and accepted, and we're here for a site plan review and their failure to comply.
Mr. Gilliams, is it fair for me to understand that the purpose for this is to establish your belief that there is selective enforcement?
Yes, Your Honor.
Okay. And the reason why you asked the officer whether he can recognize a violation is you want to ask him whether this qualifies as a violation?
Yes, Your Honor.
Okay. City, if you now understand the purpose for these questions, do you...
I do, Your Honor, and it's the same objection, because had we not had an approved site plan, I could understand the selective argument, the selective enforcement argument. Here, you're going to ask him to look at a still picture of motorcycles. You don't know how they parked, where they came from. I mean, it is what it is. I mean, the bottom line is that we're here about a site plan approval. This has been approved already, so there's nothing in that picture that would indicate, in my opinion, since it's been approved, that violates their site plan.
What is the city's argument regarding how the officer responds to complaints concerning code violations?
Well, if, again, and I thought Gilliam Jr. said they're not filing a complaint, but if they're filing a complaint that this is something that they officially observed, then that's something that they're going to have to file a complaint with code enforcement. But right now, you're looking at a still picture of motorcycles legally parked in compliance with their site plan, and I don't know what possible questions you can ask them. You know, that they turn their bikes around. I mean, I don't. And I would like. It's not germane. It's not germane.
I would like to clarify that I totally would understand these questions if we had denied their site plan for these same reasons. But at this point, there's just a site plan submitted. We have not formally denied or approved their site plan, so there is no basis that we are selective in their site plan. They are arguing some comments that were made today on a site visit, but we have not formally put those comments in writing or sent them to them as official comments, and we have not denied their site plan. So these would certainly be germane if we had denied their site plan.
So, Your Honor, maybe she's proffering and indicating that she wants to postpone this until we have our site plan reviewed, and then we can bring this back to you and complete this hearing? I mean, we'll be happy to do that.
Only because we feel that if there are some scenarios where, because usually you get permission to change your site first and then implement those approved amenities. There are some scenarios where site plans are submitted after the fact. Maybe a building is built without a site plan. We certainly can't require that building to be torn down. But these are movable objects. They are not tied to the ground. We feel that these can be relocated until such a time as the site plan. And we have had other site plans. We've sent out 8 letters. And I can talk to that about that this wasn't a complaint from Dory or from the department. It was a collaboration with the city manager's office and the community development department that July 1st letter, which was a courtesy letter to say, hey, in 31 days, we're going to be addressing these things. So I'm not sure what the applicability of showing that Florida statute was. The city will state on record that we initiated this letter as we were trying to clean up some of our sites that had unapproved outside seating areas. But that because these are movable objects, and 3 of those 8 initial letter receivers picked up their unapproved seating and got rid of them. A few of them came in and changed their site plan, but these are movable objects that can be moved.
I think I'm going to anticipate your question. That how was the officer asked to respond to this site? What was the origin of his visit?
So city, community development staff, in collaboration with Mr. Carlisle and Lisa, we initiated this letter, and the initial letter was sent from our department. The letter gives 31 days, and it does state that we would like to achieve voluntary compliance after July 31st. After July 31st, staff, myself, and another planner, we drove around to the 8 sites. We verified which sites who removed their furniture and was in compliance. And then we contacted Curtis, because the remaining properties were in his district, and asked him to give notices of violation. That was after we had discussed that with our city manager and the community development director.
So that all of that would be beyond the purview of the officer, except for responding when instructed to go to a certain site?
Yes, once we asked him to issue that first notice of violation, the code enforcement department then would follow through with their process of complying, checking for compliance, issuing the notices of violation.
So, Mr. Gilliams, it appears if you have questions regarding the origins of this, that would be a better witness than the officer.
And thank you, Your Honor, and I appreciate that. The thing is that the code enforcement officer came out in 2017 also, and they knew that this was approved, and they never bothered us until I got elected in 2019, and then I was removed by a recall. Then this became an issue, and that's why I want to tie it together. I'm gonna go ahead, and for the sake of time, I'm willing to take her up on, like the other applicant that never came before you. I'm willing to postpone this. Let's see if we can meet with staff, iron out, because we're happy to oblige and show on our survey, a scaled survey. They can take a ruler to it. 1 inch is 30 feet. We have a certified one, so she can see that we meet the criteria, and then we don't have to take up your precious time. I'll be happy to do that and comply.
Response, City.
So, again, we usually go through the review process. We will put together, and I can say that there's one project ahead of you, but once we get to that, we will put together formal comments and send them to Mr. Gilliams. At that point, if they would, usually the process is you respond to our comments, change your plan. Maybe we have questions, you submit that back. If it's been answered, we sign that off. Or sometimes engineers, once they get our comments, will say, we have a lot of questions on your comments. May we set a pre-application meeting, and we come in. So that was, and they're, even though they're saying this is certified, there is no signed and sealed survey on this. It did not have dimensions. So again, that's why we had to go out there. But we still feel that while we're doing that, it's unfair to the other ones that did remove their furniture, or the other ones that came in and also paid fees and paid $6,400 for additional parking to do that we're continue to work on this, that they can remove their seating also. It's unfair to the other 7 that came into compliance.
Hang on, let me hear from the city attorney.
Well, that was my position. We've been saying this, when did we start? Like 2 o'clock? Since we first started, that as long as they come into compliance, which is move these things wherever they got to move them out of where they're not approved.
we're in compliance.
We'll continue to work with them. Other than that, I don't know. I mean, we're still willing to work with them, but they still have to come into compliance, which is remove the tables, chairs, bars,
Let me ask
and
a
whatever.
question that might sound ignorant and Pollyannish, but let's ask it. Let's assume, for the sake of argument, that we continue this hearing and Mr. Gilliams removes the seating, and the first business day after the holiday, he comes in and the city's convinced that he's correct. Would the city allow him to return the seating back to where it was?
I want to leave that to the subject matter experts, because I think what you're saying is if the city agrees that their site plan should be approved. So I'll let her answer that question.
So we haven't done parking calculations, so I don't know what they have, whether the issue is he's in compliance from 2017 of having the tables there. The matter is, did they have the correct parking? And I know he put the cones up.
Right,
But
but hang on.
So I misunderstand your question then.
Right. Let's just assume all of that works out. Let's just assume magically that Mr. Gilliams has convinced you that he's always been right, and he has removed the seating pending that. Rather than waiting to another hearing or waiting for formal approval, would the city be willing to give him interim approval, like, hey, you know what, you're right, we were wrong, put the seating back?
So I believe that's why we're here. It is our determination that he is not in compliance with whether this site plan or anything from 2017, that we do not have approved site plan.
I understand, but here's my point. Let's just assume he's right. Let's forget all that. Just assume he proves to you next week that he's right. Would the city allow him to return the outdoor seating immediately? Because his position is his business would be hurt financially by the removal of the seating. So I'm trying to mitigate the financial damage.
Can I add something, Your Honor?
Sure.
We took the initiative and we brought in a bunch of tables that were in the driveway. And we respected what they said. So we took them and we put them out back. And if you look at our pictures, you'll see the tables are in our grass and in parking spaces that we designated. And the reason why we designated those parking spaces is because we've got extra 10 spots. We did the calculations.
Right,
It doesn't take a rocket scientist. So I would not stipulate to them having that authority over my business to say yes, no. Okay. What I would like to do, Your Honor.
Because from what I understand, the intensity is not the number of tables or seats, it's square footage. Is that correct?
And that was, yes, explained, the area of the tables so that you can put five tables in.
So if I understand it correctly, even if it's just one seating area, but it's way that way, it doesn't matter if there's 9 between there or just that one. The calculation is based on the area that is utilized for the seating.
Correct. And then we also look at how you access that area, if you're going across a drive aisle, things like that.
So is there any way he could mitigate the violation as far as the area by taking a number of the seats out so that he's not completely hurt financially, so that we can buy some time pending a review?
So
I don't know if we have the authority to do that without approving that site plan.
Okay, I'm just asking.
And I wanted to bring this up too, that is, I think we have examined what Mr. Gilliams is trying to show us that it is in 2017. That is our determination that he is not in compliance, that we don't have a 2017 approval. And there is a process that our code allows that if you disagree with staff's determination, you can appeal that to City Council. So if he wanted to appeal this to City Council stating, I believe I do have a 2017 approved plan, or whatever.
Okay.
Your Honor,
I just wanted to explore that to see if there was some middle ground.
I have a question for the witness.
For the officer?
Yes,
okay.
Yes, sir. Mr. Bloomfield, did you and I have several conversations around that if we had a site plan submitted, that we were okay to leave our tables out in the meantime, that we were in undetermined compliance, but since it wasn't a safety hazard, that since we were working with the city,
And we removed the tables in the driveway.
Well,
So
no.
who's asking the question?
we never had that conversation?
No, that's not the way that conversation went. Well, I don't think I spoke to you. I think I spoke to your father. And so what he informed me was that he submitted, he paid his fee, and he submitted some initial drawings to community development, so he should be okay. That's his words, okay? And so, and that's determined by Dory, okay? I don't review site plans. I don't. And so those were his words. He told me he submitted, he paid the fee, and he submitted some initial drawings. And so, and he said he should be okay.
And I did that objecting to doing it, but to appease the city, I wrote the check for the sake of getting something in front of them. I removed the tables that were in the driveway. I mean, and I want to get this, this is important because the city attorney is from Port St. Lucie. He understands code enforcement. He's a code enforcement attorney. I was chair of code enforcement for 6 years, Your Honor. Our job was not to hurt businesses or neighbors, friends. We were here to work with them to try to help them get into compliance. So as a citizen of a corporated area in the city of Sebastian, you owe it to yourselves and your community and the neighbors to maintain your homes, your property, and your businesses in a manner which has positive effect on the overall appearance. We did that. We went, did the drawings to show them what we're doing. We got more than enough parking with their site plans that we pulled that everybody else in the community is doing. And as chair, back in the days when I was there, you know, we would say, okay, I'll tell you what, why don't you guys get together, work it out, let's do a continuance, and bring this back and see if we can work this together. They're gunning for me, Your Honor. They're gunning for me. And my family. And it's wrong.
Your Honor, I'm going to object. If he's going to ask a question, if not,
I wanna
it's already
finish here.
almost 6 o'clock. What time is it? 5:10.
So the basis of the
if you're
code
done
enforcement
asking
program,
question,
Your
we'll
Honor,
have.
the
I'll tell
basis
you
of
what,
the code enforcement
Curtis,
program rests upon each of us to act in good
sit down.
neighbors.
You're done. Sit down.
Okay? You
Sit
all
down. You're
have
done.
property rights to
Let him
protect
make a
you.
final argument.
However, the term property rights also implies that a property owner has certain responsibilities, which I felt I've done in good gesture. No property within the incorporated area of Sebastian may be used or maintained in a manner which downgrades the value. We're not doing that here, Your Honor. We're just not. The use and enjoyment and safety of our surrounding properties. Business strategies for code enforcement is responsible for providing enforcement of city codes relevant to the land development and building construction and policies. Code enforcement officers respond to citizens' complaints and concerns. We're responding to politics, selective code enforcement in this town, violating my civil rights, violating my right to do business in this community, violating my rights to compete. They determine the nature and the severity of the violations. There is no severity. This has been going on for many, many years. They've been to my property. They never brought a notice. They never brought me in front of code enforcement. And now we're going to 2019 after recall. And Mr. Mann knows that I didn't vote for him to be the attorney. I get it. I just didn't think he was qualified. But nothing personal. I love the guy. He serves our community. But there is no violations except the fact that there was tables in the driveway. And that was a violation of the site plan. And we removed them. We removed the violation. All we did was move our tables into parking spaces that we feel, like you said, under the square box, we have plenty of parking. And we're proving that. I can show you a site plan that we submitted, not a site plan official. It's called a minor modification for furniture. So, you know, to establish and remedial the action, the time required for code compliance, maintain records necessary for effective legal enforcement, the process code cases through re-inspections, proper notifications, scheduling for code enforcement board hearings, review codes. This is a business strategy for a community, to work with the businesses. We pay taxes in this community for 30 years, property taxes, sales taxes. You employ people. Why? Why are they gunning for me and my family when we're trying to comply? I just don't understand it. But yet, they're the biggest violator. And I can show you more violations as of today. We shot pictures. If I ask them for the list of 9 people that they send those letters to, I will embarrass them. And I don't want to do that. I ask for a continuance so we can resolve this, a postponement, We could sit down, and staff should say, you know what? Let's see if we can work this out. Let's see if we can help the business. Let's go in that direction. No, they're gunning. They're trying to put me out of business. And they started ramping it up just recently. And I don't need to go into that, Your Honor.
Your Honor, removing these tables, even for a temporary time, sorry if you can hear me all right, removing these tables for a temporary amount of time is going to incur cost, labor, effort, storage to put these tables. It's going to greatly impact our income at our business. We have a lot of customers that thoroughly enjoy sitting outside. You're not allowed to smoke inside most restaurants anymore. We don't allow smokers. We will lose all of our smokers to the other establishments in the community that the city tends to favor as opposed to us. So I ask that, that we try and continue this, but have some mercy on the fact that we're going to have to remove all these tables is really going to be a big impact on us. And until we get the site plan completely finished or even get a response back from the city so that we can start working in the right direction.
We don't want to be here. We thought we'd get a response.
And they didn't even show you the letter that we asked for in a continuance. So they're clearly not on our side. They're not trying to help us. They're not.
That was directed to you.
I understand.
So that's all I ask, Your Honor.
Okay. City, response? Summation?
Yes, summation, good. Yes, Your Honor, thank you. Well, just a couple of things. First of all, I do agree with both senior and junior. Code enforcement, we know, is not supposed to be penal on purpose. We're supposed to hope in compliance. And that's the whole issue here, is compliance. Everything they submitted to you today has been either it's been already approved site plans and not. The issue we have here right now, which is the only issue before you today, is whether or not the current situation we have with the no name. Mind you now, I know they keep arguing selective enforcement or selective arguments or whatever. This is not selective. This is something that came out after COVID. We've allowed everyone to work because we knew there was COVID-related issues. But after COVID, when the governor came down and laid down, look, we're open again, no more COVID restrictions, that's when that letter went out. And then all we're doing, not only the no name bar, every single other entity which we thought were potentially, and that would be through Dory's office with community development, that were potentially in violation, all of them, every single one, 7 of them have come into compliance. This is the only one. We're not selectively doing anything. This is a clear violation of our statute, which both witnesses have testified to earlier. It violates section 54-4-18.2, subsection E, for those specific items that are outside. It's a testimony of both the respondents that we know already proper notice was provided, otherwise they wouldn't be here today. And the bottom line is that they remain in non-compliance, and that's what we're asking. We're willing to work. I mean, look, I know initially I thought the code enforcement officer was saying 72 hours. That might be kind of unreasonable because obviously we have Thanksgiving coming around the corner. We're willing to push this thing, getting it done within, 5 days or, Monday after the holidays. But the thing is that they have to come into compliance, continue to work with Dory and her office, and hopefully down the road they can get their site plan approved. But right now they have to come into compliance, and this is what we're saying, that you find them not in compliance, and that's it. That's all I can say, Your Honor.
How do you address Mr. Gilliam's contention that there were code enforcement officers in past years with the outdoor seating there, and it was not addressed, but it was addressed in 2021?
I can only tell you, I've been working since February, I think it was 20th of 2020, I think, almost 2 years now. That's all I can talk to you about. I don't know what's been going on prior. Since I've been here, we've been trying to, little at a time, address all the issues that we have. This issue came forward, and we gave them all a small reprieve for that time period for a year and a half or whatever it was. But now we're asking all the companies to come back to compliance. I can't speak about the past. All I can tell you is how we're doing going forward.
Do you have anything you could add?
Only that, I was in the city manager's office when he realized that he had been given a document that maybe had been altered, and I know he was very upset. And I'm just being blunt, it is sometimes above and beyond that when we deal with Mr. Gilliams. But I do know that currently there are questions that some of those tables and chairs are in our right-of-way. Again, we just want to establish that we are not trying to shut down the outside seating. We just want to make it in compliant with our codes, just like all of the other sites. I cannot speak for some of the motorcycle parking. If there is some unsafety, they're welcome to make a complaint, and we will address that parking. But we want to work with them. It's just that we feel that 7 other have gone and they've got into compliance. They've paid money, $6,400. One ice cream shop paid so they could get that extra parking that they needed by buying exemptions. And we certainly can work with them. We just think that in fair to those other 7, that they should relocate their seating until their site plan is approved, and we can make sure it's safe seating and that it meets code, any type of crosswalks or anything like that, and that it's out of our right-of-way.
I understand, but it doesn't address my question.
Yep.
Thank you, Your Honor. Thank you.
How does the city square the fact that there had been code enforcement officers on site in years past, and it was not raised, but it was raised in 2021?
I wish we would have pulled the records for that particular site for over the years, because I believe, but I can't state factually without seeing the records from past there, that there have been other previous issues of non-site plan compliance with the outside seating. And Mr. Anon may have something else too.
I can tell you
I was just going to add what
You want to know the difference, Your Honor?
Hang on.
Okay.
I was just going to add what I said earlier. I can tell you what happened in the past. Maybe she can. Only going forward, what we can do. And the bottom line, they're in non-compliance.
The difference is real simple, Your Honor. There was a recall election. There were false charges, fraudulent charges by prosecutors in this community. That's now on
Your
appeal
Honor, if I can, that is-
in the 4th District Court of Appeals. That's not been settled yet, okay? This is called retribution, okay? This is what this is all about. And for them to look you in the eye and be sincere that they want to help our business, 30 years in this community, I served this community, and this is how they help you? When we made the effort, in fact, we feel we're in compliance, but we went the extra yard to submit a minor modification for furniture and show them that we've got more than enough parking with the motorcycles that they already approved in their code. And we're showing you, and I still need to finish cross and examine him. I'm not done with him because I got more site plans here. You're going to be amazed as to what's been going on in this community as far as selective enforcement. Now, I'm willing to put this on hold. I'm not willing to stipulate that I got to bring my tables in because I did bring the tables out of the driveway. And I'm trying to compromise with these people. And they don't want to compromise. And they don't want to extend the olive branch to say, okay, there's not been any problems down there. Nobody's called the police. There's not been any issues to justify what they're doing. Let's just go ahead, call the timeout. Let's postpone this like the previous application this afternoon did, and said we'll come back in 60 or 120 days to try to resolve this because it is the holidays. That's all we're trying to do here. I'm not trying to put somebody out of business.
Well, let me ask you a question. From the testimony today, there were 8 letters that went out. The other 7 have complied.
Negative.
Hang on. The other 7 have complied with the removal of the seating.
We did that.
All of it.
No. We feel back in 2017, we're approved for that other stuff. That's furniture that's been already approved. But the stuff that was in the driveway, we respected it and we removed it. And then we came in and went the extra mile.
What is your basis for believing it was approved in 2017?
The fact that alcohol and tobacco came out, gave us permission to serve at those tables. Health department for hotels and restaurants came out and gave us permission to serve food at those tables. And the fact that the code enforcement officer was out there for 3 years, off and on. And I know Kirk personally, and he's a good man. He's just the messenger. But they knew that this all started happening after the recall, okay, when those false charges were brought against me.
So
Now,
what is the city's position regarding approval in 2017?
Sorry?
The BAT application.
The ABT application, the Division of Alcohol and Tobacco, the State Health Department, and the other code enforcement does not have the authority to approve a site plan. That is the City of Sebastian per our Land Development Code. And the City of Sebastian feels that it's staff determination that we do not have an approved site plan on a survey and/or a civil engineered plan.
All right, so just so I understand, is it the city's position that even though the state came out and said, yes, you can serve alcohol, yes, you can serve meals, is not an approval of the outdoor seating or the site plan?
Correct, because there are parking requirements, there is location requirements that possibly could be, and not that they don't have the parking, we just don't have the calculations yet, or that reviewed or signed off, and that there may be some encroachment into the right-of-way, and not speaking generally, not just for Mr. Damien, the no-name site plan, but other site plans to verify that parking, that extra seating isn't in stormwater. The train station had to move a picnic bench that they had in their stormwater area, so location is also important. And the State Department is not aware of our codes, so they don't know what those parking requirements and location requirements and/or a survey if they were in the right-of-way. So there isn't a way that they could have signed off
So
to
is
the
it
city
the
for that.
city's position that the only entity within whose purview this falls regarding approval of the outdoor seating is the city of Sebastian?
Yes.
Regardless of what the state had said or approval?
Yes.
So it is the city's position that the state's approval just allowed the theoretical serving of food and alcohol, did not approve the sitting of patrons outside. That's solely within and exclusively within the city's purview.
Yes, I believe that the alcohol division was verifying that it was on their property and that it was not within a church area or anything, a school. That's what we sign off. Health Department was probably checking that they, the type of silverware and the plates and where the food was being served. That was their purview, and that is our then the city is responsible for those other items under their purview.
So they were looking at the process
Other items,
of providing food and drink,
correct.
not the actual location of the food and drink.
I think they only had to verify that it was on the private property, correct.
Your
Now,
Honor, city acknowledged when Joe Griffin gave me a permit to close down my driveway in the back, which affected my site plan. He acknowledged that, yes, you can go ahead and put furniture outside by issuing me a permit to put the fence up, so my traffic pattern on my site plan was modified to allow that additional stuff. The city acknowledged that back in, when the code enforcement guy came out, 2017, and said, hey, and I gave him the paperwork, and nothing ever come about it until 2021, 2020.
In refute, that's not what's on the building permit.
Hold on.
Why,
Let
I don't
him
understand,
finish.
I don't understand, why are they gunning for me? Why can't they just say,
Let him
Mr.
finish.
Gilliams, you complied, you're compromising. You took the tables out of the driveway. We did that, we put them in the back. I spent a lot of money for those tables. But for crying out loud, we're taking up a few parking spaces, which is our decision for picnic tables that we've had there for years. Why, until we get this done, what is the hurry? Why is it they just can't say, let's do a continuance, let's do a postponement, and let's resolve this so that we don't have to appeal it. We don't have to go to clerk of the court and file motions and file records and have 3 judges. You know, it's not necessary. That's not what code enforcement is about, Your Honor. It's to help people to comply. That's all how we did it back in the day. There's an owner, a piece of property, they didn't have the money to fix it. We gave them time. We said, hey, you got plenty of time, come back and see us in 30 days or 60 days. We weren't out to hammer people. That's not their job. Their job is to work with people, to help create jobs in the community, especially under COVID-19. This thing is far from over. Okay? It makes no sense. But I do have more evidence to show you how selective they are, and if I'd like to get the 9 businesses that they sent, I'm willing to put this off temporarily until we have a chance, and let us breathe so that we can figure this out. And it sounds like they're not negotiable.
so let me ask you a question about an issue he brought up regarding the tacit, allegedly, approval by Joe Griffin when he was head of CRA? It was
No,
not
he
when
was the Director of Community Development.
Director of Community Development.
In 2013, he
Moving
was,
into the city manager's position.
In 2013, he was Community Development Director. In 2017, he was City Manager.
Okay.
And the permit that he signed off on was for a privacy security fence. There's nowhere on that application that stated that it was for outside seating. It was for security.
The permit from the state was already approved, tiki bar, the outside furniture was already approved. That's why we put the fence there. And it was there for the property, the front, and they knew that. They knew that. This is their way of saying, okay, we'll see you in court.
So how do you address the other concern that the city has raised, that there was a modification to the documentation, that it wasn't just tiki bar, but it was tiki bar and...
Tables and chairs.
Well, tiki bar has chairs in it.
Yes, but the documents that
I'm
the city has...
I'm happy to go off whatever, I have my document from the state that's been signed off. Tiki bar, chairs, you know, it's all the same.
The city is saying it just said tiki bar, but the documentation you presented said tiki bar and tables and chairs.
That people who come to the bar, sit at the bar, take their orders, they sit down at the tables, just like they're doing at Hurricane Harbor. They don't even have the restaurant. Krabby Bill's, you gotta go up to the front, make your order, and then you gotta go to the Historic Society. And the Historical Society has the tables. They're the ones that are putting the tables out front for Krabby Bill. So they're in violation there too. I don't know why they're making a big deal of this. Why aren't they willing to help and say, hey, we'll see you in 30 days, the next meeting. Let's leave this on the docket. They did it for the other guys. Why aren't they willing to budge and negotiate? There's no safety here.
Let me just do this.
To be blunt and upfront.
Let's take a 5-minute recess. It's only 5 minutes. So you guys can have conversations off the record to address that point.
Thank you, Your Honor. I'm happy to do that.
Just that point, just 5 minutes.
Sure.
You're not off.
Okay, we're back on the record. Come on up.
Just to conclude our position, we reached out to the two people who signed the letter back in July to see where they stand as far as that, and both of them are asking questions, and Dory could fill it in. Both are asking questions, what have others done, and obviously everyone has complied. The issue is, I'm going to circle back around again and try to go back. I know we've been everywhere for almost 4 hours. The issue is, circle back, what we're here for. We're here for whether or not this specific site is in violation, at this point in time, of their, by the outside seatings of our code. And that is the evidence that we presented, and we still stand by the position. We're willing to extend it because it's the holidays, maybe till like Monday, for them to comply with it. But other than that, the same recommendation that Mr. Curtis Bloomfield mentioned earlier is the same position the city has at this point in time. I don't know if you want to add anything about.
I can verify. I spoke to Ms. Frazier. She did also ask how we had handled some of the other cases, specifically Mo Bay Grill, because they also had some seating that they had in front of the restaurant. They took that away, but they put it onto the side. And they claimed also that there had been that had been there when they moved in 5-6 years ago. And what we said was it may have been there when you moved in, but it was not approved. We went through our files. There was no approved site plan. They removed the seating. And so...
removed or moved?
Pardon me?
Removed or moved?
Removed off of the site. There is
Okay.
no longer any seating. And so she feels that to be fair to all of the other businesses, and I can honestly state that I have people that do come in and say, especially the ones that came in, they said, well, why does No Name still get to keep their seating? Do they have an approved site plan? No, not yet. It's been applied. And they have said to me, well, why do we have to move ours then until they have to move ours, until they move theirs? And so we're trying to show that we're not showing favoritism for this particular site, especially over the years, and some of the other existing violations that are on there, outside storage of an RV, dumpsters that are not painted to match the building are falling apart. They have other nonconformities that we could cite. And that's what other businesses say to us. Why do they get to keep it with their nonconformities, but we have to meet our code? And so to be fair, as what we did with No Name, Ms. Frazier said that she could understand us extending that to 5 days till Monday to remove those tables. At such time, we continue reviewing that site plan. At time when that's stamped off, they can put those and once everything's implemented, they can put those tables back into the areas that have been approved.
The other thing I want to mention, my conversations with the two, is that all these seats that we're talking about came into place after COVID, meaning once COVID came in, that we relaxed it, all these seats were in place. It wasn't something that was there prior to. That was my understanding based on my conversation. Secondly, even after we told them in July that things had to be removed, they continued to add certain things, like I heard a pit, and that wasn't part of the complaint, but still, all things are not in compliance. Again, the issue is, circle back around, what we're here for. We're here for the fact that they're in violations at this point of the code. All those things outside need to be removed, and they can continue with their process. And same thing that Mr. Bloomfield mentioned earlier, still remains the city's position to this point, other than the fact that we're willing to extend it till Monday.
Okay, well, that's something new, and so I leave it to you. Do you accept or reject?
No, absolutely not going to accept that. The fact that it's ludicrous, the remarks and the statements that he just made, and the testimony that we heard today so far from the code enforcement officer that we were existing back 27. You hit it right on the nail, Your Honor. Why didn't you square up then? And we all know why. We're prepared to, it's not our fault that government doesn't staff their community development department with proper staff to review their site plans. There are some cities that require a response immediately. That's how you get business in the community. There's a lot of vacancies out there. Businesses are closing. Jobs are being lost. So we did the right thing. We removed the tables. Now we have to decide, do we have enough parking? We felt that we already had approval. We showed the evidence. It is very clear that we got approval by the Director of Community Development. We're prepared to show you again with some of our presentation about how we're selectively being forced on. They're picking and choosing the winners of this community. And it confuses me that the city attorney says, well, we don't have the authority, but he had the authority early in the meeting to negotiate and give those people 60 to 120 days. But his superiors are three votes from the city council. I'm not sure who he called, and I don't care. But it's just, it makes no sense to me. Did he call the city manager, my favorite guy? And I love Paul Carlisle, don't get me wrong, just we respectfully disagree. But Paul Carlisle's not going to negotiate and be fair with a business in this community. He's out to gun for me, and I get that. I understand that. But the evidence is very clear, Your Honor, that we've compromised. We showed that we have state licenses. We showed the code enforcement came out and he knew about it. They all knew about it. But we're prepared to finish our cross-examination with Kurt. We wanted to see about the 9 other businesses that they talked about because we have documentation as of today showing that they're not in compliance. And I want to verify his number. I mean, I can look it up on my phone, but I want to verify the 9 other businesses they sent the letters to. And we'll show you.
7 of us.
7. Whatever, 9, 7.
Your Honor,
So
we made submissions
we're prepared
already. We're not
to
calling
go
any
on
more
with this
witnesses.
and present our facts that we have.
Let me ask a question of the city. What would happen if I were to rule against the Mr. Gilliam's, and subsequently his site plan gets approved? I assume the seating goes back?
Yes, into the areas that would be approved. We verify that it's not in the right-of-way, it's safe for pedestrians to get there, crosswalks, whatever, but yes.
And if he does not remove the seats between that time and today, he would be fined? The officer asked for, was it $100 a day?
That's correct.
That's correct, Your Honor.
What would happen to the $100 fine if subsequently the site plan is approved?
I believe that's when the fine would stop. If
Okay.
it was approved. Now, there may be some, they still have to implement if there's any wheel stops or new striping or anything like that. Once it's implemented and the site plan is signed off and it's implemented, then that fine would stop.
A more direct answer is if they're in non-compliance, which they are, until it gets approved during that time period, that money gets and implemented, correct, then that continues to have a daily fine until it is ultimately approved and implemented. So the fine will continue to accrue.
Okay.
And then ultimately we'll have a massey hearing about that.
Okay, so you have evidence that some of the other restaurants who were purportedly in compliance or not in compliance? What are the names of those restaurants?
Why don't we ask the code enforcement officer, those 7 businesses or 9 businesses, they originally sent the letters out. I mean, I have them on my phone, but I'm sure he can, otherwise we'll have to take a recess and I'll take them out for you. Because they sent me, the clerk sent me the 9 businesses.
Let's get the list, and then you tell me whether you have evidence that they're not in compliance.
And not only the ones that they sent the letters to, but we would be happy to share with you, Your Honor, multiple businesses that are not in compliance with their site plans, because we requested all those documents.
One issue at a time.
Should I read them into the record?
Yes.
Mo Bay Grill, the train station, No Name Bar, Paradise Ice Cream, Village Tavern, CC's Place and Sandwich Stack, i.e. River Park Plaza, Squid Lips Dock Area, and Portside Restaurant.
Okay, and you have evidence on which ones that they're not in compliance?
So she said Paradise Ice Cream, the Village,
Village Tavern,
right, the CC's,
yes, which is River Park Plaza.
right, Riverside, River Park, okay. What was the other ones?
Squid Lips dock area,
Squid Lips, okay.
the dock area, east of their on-water restaurant, Portside Restaurant,
Port Side.
Mo Bay,
Mm-hmm.
train station, and No Name Bar.
Okay, we're ready to proceed with the redirection.
So which, do you have evidence on which ones of those?
Well, we have, on these here, we have the Riverside Park property next door that, after reviewing their site plan, they're not in compliance. We have,
Not in compliance with this requirement, we're not worried about not in compliance with their site.
talking about tables outside, Your Honor.
Tables outside, that's
Yes,
all
sir.
we're worried about.
Correct. And you can see how it wasn't even done with an engineer, it was done by the owner, just, you know.
So which restaurants?
I'll be happy to show that whole.
Your Honor, one of the other establishments, it's kind of a tricky way, the way they went about it. It's, I believe, technically Portside's property, but it's also Paradolia. And I believe that Paradolia was on that original list for having a bandstand outside as well, that they were using with their outside tables. So I'm not sure why they're not included on the list.
All I'm worried about is if you have evidence on any of those restaurants that are not in compliance.
We have evidence of Portside. currently.
Portside?
If I understand the property lines properly.
And Paradol, we show that, and the Riverview, they have tables outside as well.
Okay, are those all in your district?
He's asking me a question. I understand that. He's asked the magistrate.
Are they are any
Yes.
of those in your district?
Yes, they are.
Are all of them in your district?
Yes, they are.
Okay. So you would be the one to know?
Actually, Dory would be the one to know.
Okay.
But we've both done visual sites to see that the tables had been removed that
That's
were in the wrong place.
Okay. And you have reliable information that they are in compliance?
With regards to the outside seating, yes.
What is your information regarding, let's pick one.
Your Honor,
Pick a restaurant.
if I just can, while he's looking to that, I really don't know. I mean, I know, and I'll give you the deference to allow this to continue to sidetrack. I don't understand why, and I'm trying to bring it right back. We're not here for anyone else. If it's an issue, let them raise it, and we'll go out there, and then they'll be in here next month or whatever.
The issue he has raised, very emotionally, is selective enforcement.
Yeah.
And it is the city's testimony that that everyone else of the 8 letters is in compliance.
Yes, that's what we testified.
He is rebutting that, saying that he has evidence that certain of them are not in compliance.
We'll see what the evidence is.
Your Honor, I brought a couple of the site plans that came in, but I may need to run and get a site plan depending on which one he's bringing up. I have a couple with me to verify that they're the most recent site plan.
Okay, so,
Pick one of the restaurants. Which one do you have evidence on?
okay. I'm going to start with the Parabola.
No. You want to start with the park? Riverwalk?
Do you have pictures?
We have site plans, and we have pictures as well of some of the other properties.
All right. Do you have pictures of seating outside?
No, it doesn't even reflect it.
So do you have pictures of any of those 7 restaurants with seating outside?
Yes, we do.
I'm
Who
sorry,
do you have?
which site is this?
Which restaurant do you have pictures of seating outside currently?
We have pictures of Paradolia and Portside having seating outside, and I drove by there earlier today, and they still had tables outside. I saw somebody cheersing somebody with an ice cold beer, and I noticed because I was a little jealous.
Response.
So they have been.
Which one are you responding to?
Portside Restaurant.
Okay.
Is that the site that we are questioning?
I believe the property is owned by Portside, but Paradolia is utilizing it.
which is why the notice went to port side, because they would be the ones that would be liened, because it was unapproved seating on the port side property.
Right.
So the letter went to port side.
Right.
They removed what Paradolia or whoever it was removed. Port side site plan does have outside seating directly right behind their building. There is a percentage of square footage, a square footage amount that they are allowed to have directly behind the restaurant.
That is not the outside seating that we're referring to.
Otherwise,
There is outside seating in their driveway directly next door to Paradolia that is currently out there as of this afternoon. And we have a picture of it that we can show.
okay, then that was outside seating, then it's driving past. I cannot speak for that seating, but in terms of the site plan and where they have, if somebody placed the seating there, then that is, they came in, they removed what they were supposed to when we went through and did our inspection, and based on their approved site plan.
So
They didn't change their site plan. This was their approved site plan from a few years ago. When we did our inspections after that letter, they had changed, they had relocated all of their tables that they needed. Now, if this is a new violation and the seating is there tomorrow, Curtis can open a new case that they have outside seating that's not for their approved site plan.
We have absolutely no interest tonight in opening any new code enforcement violations on anybody in the community.
Yes.
All we're saying is that there is somebody today, this afternoon,
Yes.
with tables in their driveway, not in the grass.
What we are verifying is that after we did an inspection,
And you
they were in
had said that
compliance.
everybody was in compliance, and if they are allowed to have tables in their driveway, and that's allowed, and that's in compliance, then maybe I misunderstand.
So all I can say is, based on the testimony, when they came forward, they have complied, and we closed out the matter. Based on this testimony from the no name, I will definitely instruct Curtis to go out there tomorrow and look at, because now this is a complaint that they're lodging against.
No, this is not a formal complaint.
It doesn't
I want
matter
to
at
make
this
that
point in
very,
time.
very
This is
clear,
a
Mr.
formal
Anon. This is
hearing.
not a formal complaint.
Then you know what, they need to retract what they're offering as evidence, because this is ridiculous. Either you're complaining about someone, and she's testifying clearly that when they brought their packet, they met, and they went out and they inspected. These are what two officers are saying that they've done. They were in compliance. If they subsequently did something unbeknownst to us, and now they're bringing it to the city's attention, then yeah, that is a formal complaint, and this is a formal process. So yes, I would recommend, if that's a separate matter now, we're still here for them, their case.
Yeah, we're talking about selective enforcement. That's the part of the argument.
And we answered the
feel we're in
question.
compliance. We showed we are in compliance. We showed documents from the state we're in compliance. We showed documents from the city manager, the community director, that he signed off on it, gave us permits to shut down so we can do the outside thing. Now, I'm ready to share the pictures and the evidence.
I actually have a photo that was, I can show them. This was just taken about a minute and a half ago from somebody that just went over to the property, and I can show that the tables are still there.
There you go. Your Honor, they can't pick and choose. We're trying to get compliance here. If now they're offering evidence for the first time, which our testimony is.
That's the train depot.
You can
see that the photo says now that it was just submitted to us. These are the tables, this is the driveway. From what I understand, that this is Portside's property, but Paradolia utilizes it. But either way, there are tables in the driveway that have been there ever since this has started. And I believe they were on the list, and if maybe they're in compliance now, maybe they have approval to have those tables there in the driveway. That's something you can educate me on. But from what I understand, they do. Microphone, please. Sorry.
Microphone, yeah, carry this around.
I think that's what she did testify, that they were in compliance. Now, if there is a subsequent violation, then that's something we got to address tomorrow based on these allegations.
So it is the city's testimony that the city investigated all of the other restaurants that received a notice and was able to verify that they had complied. Whether they have subsequently relapsed is outside the purview of this hearing.
Or some of them have approved site plans as well.
Okay.
So, if I can proceed, Your Honor?
Sure.
This is a picture of my neighbor. I don't want to, this is one Riverwalk or River, they got a letter. So, Mr. City Code Enforcement Officer, do you see that building there? Do you know what restaurant that is in that complex? Italian, yeah.
I would like to see too, I'm sorry.
It's Italian, it's right there. See, they have outside seating, okay? They still have it. That's not on their site plan, because we just got this site
There's
plan.
not a table there for seating.
It's outside furniture, Your Honor.
It's
Okay?
for a waiting
So if she
for
wants to
line.
split hairs, okay, let me continue, just to show, this is one business in a complex that they overlook selectively. So, let me go to the next, and I here's another one.
Well, just for the record, that Italian restaurant was not one of the initial 8, but now it would be.
We'll talk,
It's not outside seating where they serve food.
Oh, there you go. So
it's
the
outside
answer is it's
furniture,
not-
it's outside furniture, it's not the restaurant's fault.
Okay,
It's
he
the
offered
property
the
owner's
picture.
fault, and they served the property owner. They notified him.
He offered the picture, she's offering the answer.
So is there more seating outside? That's the same complex. You're familiar with that, doctor? Right there?
Yes.
Advance? Okay. No, I'm cross-examining him, and we're done with her.
You can answer the question, if you have
There's, Paradise Ice Cream has tables approved seating. They
Here's-
changed their site plan in front of
Yeah,
Paradise.
yeah, here's Paradise Ice Cream.
Yes.
You see tables and chairs out there?
Yeah,
Mr.
well,
Cohn?
those are approved.
Yes,
Those are approved?
Yes.
They're on the site plan?
yes.
Okay.
They had to buy 2 parking in lieu. They paid $6,400 for their extra parking that they needed.
Tammy, can you verify that right there? Because I didn't see that, the ice cream.
Nautical Road, proposed seating. It says proposed.
Right. But they got approved for the seating that's behind the building. It's not approved for the extra seating they put in the front of the building.
Yes, they
So
did. It went before City Council on October 13th, 2021, for the parking in lieu.
It's not
for that
reflected,
site
it's not
plan.
reflected on their site plan.
I'm not sure.
I asked for the most updated site plan, and it's not there.
3 months ago. You've asked for, some of those site plans were almost 3 months ago,
No,
dating on
this
October
is,
12th.
I can show you, the clerk of records sent that to us just recently. I've got it on my phone, I can show it. But, so, yeah, they had some additional parking in the back that they went ahead and they submitted for in lieu of parking. I understand that, it's a shakedown. They say, all right, you want more tables? Give us money and we can, we'll give you extra.
$3,200 a parking spot.
Yeah, we could give you extra parking in lieu of, give us some money. To me, it's a shakedown by the city. They're not looking to help businesses. So that's just that one property there. Then if you go over to the next one, Cece's, and again, they got a table and chair. Did they get one for Cece's too?
Yes, not parking. There is an approved site plan from 4 or 5 years ago with the parking spaces that are right next to the building, right adjacent. They don't have to cross the drive aisle. That is on that site plan. There were tables and chairs along the sidewalk. They were supposed to appear today, but they did remove those. As of yesterday, all of the unapproved tables and chairs were removed from the sidewalk.
Ma'am, this site plan shows 21.
21 what?
When they went for the modification here, they went for, it shows that the signature of the owner, June, actually, let's see here. There was one done.
Right here.
Yeah, I understand that.
No, it's on
In
here. There's
the
a 21.
18th, and then this one down here, for additional seating, was done on the 21st, and it's not reflected in front of the businesses. It's just, yeah, that's the, I'm talking about this business over here. So he's got a note here on their site plan for the additional outside seating. It's not, that's back in 18, approved by the city council. Okay, and we just got this, but it doesn't show it in the front on their site plan, additional tables. So
I think she has an answer.
yeah.
So this is the most approved site plan. Let's see, you can see. Here it is, in front here. That was the approved that they had to buy parking in lieu for. There was the sign-off. It was 7/29/21. We did allow them to hand draw this in because this is a civil engineered plan from 2015. And as you can see, it has very detailed parking calculations. So it was easy enough for us to quickly calculate. And then this is the plan that was presented to City Council to do the parking in lieu. With regards to the parking in the rear, as you can see, there is, all of these areas have been roped off, proposed seating, and over here. They were to come, right here. They were to come before council, or the magistrate today, because they had a picnic table here, then all along here they had seating and chairs. And Curtis went by the site yesterday, or I apologize, yesterday afternoon. I did go by,
yeah.
I went by, and the seating has all been moved, so that's why we.
That's correct.
But otherwise, all other seating for this site has been approved.
Any other of the 7?
I'm sorry, Your Honor, what was your question?
Do you have evidence on any other of these 7?
Yes, I have a better photo of Portside that I can show that's less blurry so they can see what I'm talking about.
So
Okay.
she referred to the front there, that he cleared them yesterday. But we were just recently there and didn't say anything about the eye doctor in the other building. It's got tables outside. Okay?
only
And I
worried
have
about-
those pictures right here.
We're only worried about restaurants and the 7 that got the.
This is all part of the same
And
property, Your
for the
Honor.
record, chairs outside do not require site plan if they are used for seating. Restaurant seating, bar or food service area, those become seating areas that require parking. Having a chair outside for customers to wait outside because of COVID or a long line.
We
does not
showed you we
require
have
site plan.
10 extra parking spots, done just like all the other bars in town, with motorcycles and parking. We have 10 extra that we're not even going to use.
And our calculations are just as
Do
sophisticated.
you have evidence on any of the other 7 restaurants?
Yeah, all right, so we got that one that we just showed you. Squid Lips, they have a platform in the river that's been there for 25, 30 years. They call it an observation deck, and they say, well, we put tables and chairs out on that.
But that wasn't the issue here, correct?
There was,
Correct. East of the existing restaurant, not the concrete slab, east of that, we had noticed that they actually went to the state to modify their submerged land lease to be able to use some outside seating for the restaurant on their marina docks because of COVID. They got approval about 3 weeks before our letter went out, and we realized that it wasn't on the site plan. They did not have seating approved on their site plan for that seating. And once they got the letter, they were one of the 3 that removed it automatically. They have a new site plan that's just been approved. They are going to be expanding, blah, blah, but with regards to that particular seating that they were cited for, removed it. And they actually went to the process of having a state modify their submerged land lease for that seating, and then they removed it when we sent the letter out. So that's no longer on their site.
Any other restaurants?
yeah, there's one that they didn't even bother to notice.
We're not worried about that. I'm worried about
Okay.
the 7 other restaurants.
Okay, no, I think that after looking at the list that they provided,
Okay,
Your Honor,
so,
our point was just to show that they had said that everybody else besides us had removed their tables, and that's why we must remove our tables. And our point was to show that there's at least one business that still has their tables outside. As of currently, 2 or 3 minutes ago, from the active photos that we just got. And like I said, we're not trying to call in a complaint on them. We're just trying to ask to leave our tables there while we can figure this out with the city, still pending approval on our process.
we've removed the tables that we felt that
They're not in the driveway anymore.
they're not in the driveway anymore.
There's no public safety issue whatsoever. These tables are in the grass.
any other closing argument for the city?
No, that sounds like a summation on their part. Our position
haven't
still
even started
stands.
yet.
Our position still stands. We still have 3 more cases after this, by the way, and it's 6:15.
I understand. So if you could bring your summation to a close.
Well,
No more cross-examination.
No, I understand that, Your Honor. I understand
Do you
that.
have any more closing argument?
This was their presentation, us cross-examining them. We didn't get a chance to present our side yet.
All right. Do you have any witnesses you wish to present?
I'm going to present my son as a witness.
Okay.
All right. Would you identify yourself, please, as to who you are and your credentials?
My name is Damian Leafe Gilliams. I am a computer software engineer from the University of Florida.
Your Honor, my only objection is if he's going to offer something totally different than what they've already been crossing these people, then that's fine. Other than that, that's my objection to this witness.
Do you have any new information that your son has not testified before?
No, he has not testified to our site plan.
Okay,
It's new evidence.
We would like to show you our site plan.
okay.
If you can show the honor.
I
We
need
can
the-
over here.
Yeah. If you could, please. So forgive me, with limited space up here, I have the paper folded. I'll be able to show you the rest in a moment. So you can see our existing parking spots here and here, and we have parking spots. I'm sorry. Yeah, thank you. Help me out.
There we go.
There we go. So this is the modified site plan that we had sent in pending approval. And we had added motorcycle parking in a couple of our spots, as well as in areas around the building where there's absolutely plenty of safe space for those motorcycles to park. And you can see over here, we have the motorcycle parking that we had discussed earlier. One of Dory's complaints on our initial feedback that we had gotten is that we did not show where are we going to put arrows, where are we going to show, traffic patterns, and how are people going to get in and out of this parking lot. So we added the parking arrows. We showed how motorcycles could access the areas that we had proposed. We showed how we were going to change the parking patterns, even though we really felt that we didn't really need to make any of these changes, that we were going to show them that we're going to comply and we're going to do the best that we can to appease them and make sure that we have all of the parking that we need. So this is a black and white copy, and you can see it a little bit. We have dimensions. They had testified and said that we didn't include dimensions. We have dimensions. We show the drive aisles. We show where the arrows would go. We show where signs would go if we needed to have them. We showed everything. And the calculations, they're color-coded. Hold on. Unfold it. They were color-coded. They're just as good as all of the other site plans that have already been approved. We show where we can put our parking. It's more than feasible. And they say they make exceptions for certain properties to allow them to handwrite on certain documents. I mean, if you look at our document here, it's pretty clear to see where our business is, where we want to keep our parking, and where we want to put our tables. It's very, very clear. And I'd like to show you one of the other businesses in town, not one of those 8 or 7, but just another business in town. And like I said, this is not anything against them. We don't want any code enforcement violations going out tomorrow.
Again,
This is, please don't interrupt me, Mr. Anon. So this is a site plan where they went ahead and they highlighted and they used Sharpie.
I have to, because you're witness.
You don't have to, you choose
I
to.
do,
So anyways,
because
here's
you're
their
a witness.
handwritten document that they submitted
Sir,
along with their
My
paperwork.
objection is he's supposed to be a witness, and I've heard no questions other than a diatribe at this point in time. That's my objection.
Well, he can ask me all the questions, or I can just go ahead and give you the information. We're trying to get out of here. I don't want to spend my entire night here in City Hall. That was never my plan. So, I mean, if you'd like, we can go through Mr. Anana. He can ask me all of these specific questions, and I can answer them. It will take twice as long.
Well, let the magistrate, it's his...
Trying to get to the point here, Your Honor.
Sure. If you'd like to get to the point.
So, again, this is selective enforcement, selective site plans. These are our friends. This is how we do it. But you're going to play by the rules, Mr. Gilliam. You're going to go ahead, and we're going to make it difficult for you. And that's what this is all about. This is nothing more. There's no violations here. And
Anything else you wish to testify?
is there anything else?
One moment.
Who do I submit this for evidence?
Any objection to being introduced into evidence?
I don't know what he's submitting, so yeah, everything that he's been shown so far to me is not relevant. So yes, I do object to everything, but I don't know what he's submitting.
What do you wish to introduce into
Who
evidence?
wants to submit all the site plans? that we went over today. I wanted to submit the pictures showing selective enforcement.
So your only objection is relevance?
Yeah, well, for sure, when it comes to those pictures, we already testified that it's not relevant, meaning the only pictures he showed us, which was, I forget which one, I think it was Earl. Everything else, to me, yes, it's not relevant at this point in time, and I'm not sure what he has. I would like to see what he's going to submit to make sure nothing else gets submitted into the record.
Show the city attorney what you wish to introduce.
Everything that we would be willing to submit has already been on the projector earlier
All right,
tonight.
well,
There's
he
nothing.
would like to see specifically. So.
Absolutely, come on over. That's just a.
No, we got more. Yeah. I'm going to submit them. Let me have that. Let me get them. Give me that one too. Give me that one.
So if I may, I'm going to ask myself a question. And
I'll
my
take
question that I ask myself is, Mr. Gilliams, have you and your business attempted to rectify this problem with the city of Sebastian? Yes. Mr. Gilliams, have you received any sort of response whatsoever from the city of Sebastian besides coming out personally to serve you? No, I have not. Mr. Gilliams, would you like to solve this problem very quickly? Yes, I would.
Okay. Can I address now the evidence? Okay, so the first couple of pictures I'm seeing here dealing with Krabby Bill's, of course, object to it. We already offered testimony that Krabby Bill's under an emergency situation, and it has nothing to do with their issue, with their violation of their site plan. So I do object to the evidence of Krabby Bill. I do object to... Relevance? Yeah, based on relevance, based on what I just said. Also, I'm objecting to similar, because this is not even outside seating, so I'm not sure what that's all about. I assume these are all...
Your Honor, I object to his statement because it's for outside seating, it's site plans.
He has the right to make his position.
I'm objecting everything that has to do with Earl, because we already testified that, first of all, these are still pictures, and we were testified that they have a site plan, and these motorcycles are perfectly permittable to be there. I don't have an objection to the pictures that we've already submitted, which is our 4 pictures, and I will defer this to Dory now. Dory, what are these site plans? Hold on, Your Honor.
This is Damien's old site plan for the Tiki Bar, that he knows he'll get something back stamped, because this was Damien's site plan. But this has not changed, and so that is why we allowed, that is why we have allowed the Pinson head to come in with a...
The Tiki Bar hasn't changed in 10 years?
That this has been the... Do you have the second part to that part that you just brought up on the... Yes. 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 Paradise Marina.
Paradise Marina?
Yeah.
Okay, we don't object to the Paradise Marina because that's our document.
Just a river walk?
Yes.
Same thing?
Yep.
Ours is ours?
Yep.
I don't see the relevance. I am object to the relevance of these things, but, so I strike it back. I do object to the relevance of the other site plan. The second site plan is Rivera, same thing, it's relevance. And what was the third site plan for whom? The last one. Was which one?
Tiki Bar?
A Tiki Bar, that's his?
Yes. Yes.
Okay, well, okay, I'm sorry, I apologize. This is theirs?
No, not that one, the other one.
Oh, this is ham and eggs. No, this wasn't even, this, he never brought up. We didn't
Okay,
discuss this.
And the one about fat boys, we've never even seen that one.
Okay.
So everything is relevance as we argued everything is relevance as we argued during the matter when they presented them.
We're going to, Your Honor, the restaurant right next door to the Riverview there, the site plan, again, it's another site plan that does not depict, any seating, any tables. It's just one big block. And I get it. I understand.
So the only objection is based on relevance?
Yes. Based on relevance, yes, Your Honor.
Okay. Overruled, all that is submitted into evidence.
Thank you, Your Honor.
Any further close?
Would you
No,
guys
Your
like
Honor,
to cross-examine me?
We're ready for ruling.
Your Honor, yeah, I'd like to close real quick, and I apologize, but I think we submitted enough evidence here to make our point in case. And basically, let's go back to the basics of why we have code enforcement. And the reason why we have code enforcement, as I served this community for 6 years and with other citizens of this community, it was never our position to gun down homeowners and whack them with liens on their property. It was always about how can we do, what can we do, who can you see to get you into compliance. This here is more or less political, and I understand that. I get that. But the fact of the matter is the evidence was very clear that we were approved by the previous director of P&Z, Community Development, Joe Griffin. We were approved. He was also went on to be the city manager. He went and approved and allow us to get permits so that we can put our furniture outside. The evidence is very clear on that. The state's evidence is very clear. They have incomplete documents, but we showed you full documents of approval by hotels and restaurants, approval by alcohol and tobacco, a fully completed application. Did we try to meet and compromise and understand their position? I think we did. We went ahead and we removed, how much was those tables? $1,000? $1,000 in tables and chairs that were in the driveway.
Not to mention the income that would have came with those tables and chairs.
We said, fine, we understand your position. We'll go ahead and submit and do a clarification. I never wanted to give them another $350 just on principle, but I thought it was let's just go ahead and try to get this behind us. For me to retain an attorney and start filing appeals, I thought it would be easy just to show them, hey, we have extra parking. How can you help us? They won't even get back to us. 2-3 months gone by. It's not my fault they're understaffed. That's not how you take care of the businesses in the community. Even just pick up a phone call and say, hey, you're in the pile. We didn't get anything. All we got was, let's go down there and let's measure up at least what can we find. And Your Honor, this is dear to me. I wanted to bring a picture. I wanted to try to build a hotel in this community. And when you get the Chamber of Commerce go against you, and you get staff, every time my engineer submitted a set of plans to these guys, he would give them 28, 30 items. You address these items, we go to planning and zoning, right? And I'm going to show you that picture one day. I'm going to bring it to you. And my engineer would address all those items. All the other businesses, the hotels in the community, got favors, waivers. They got exceptions. They went the things that I asked for, the backing out on Indian River Drive. But now they're all doing it because they came from me. They wouldn't even issue my permits to fix the roof down there at one of my businesses because they had it out for me from day one. From day one, they had it out for me. That's why I ran for city council for 10 years. They're so dishonest in this community. And for them to testify today and put the evidence in front of you that was wishy-washy, you heard the code enforcement officer, he was very sincere. He understood. And, but they kept moving the field goal posts. Every time my engineer said, all right, we're going to kick it through, we're ready, we addressed everything, they go, okay. So I went to City Hall and I asked the clerk, can you pull out my box from community development for that project and put it on the table? And Jeanette Williams did that for me. And I said, now go over to this other, and I'm not going to mention the company, but they're big political in this town, and they built multiple hotels in this town. And they put his file there. So help me God, his file was this big. With waivers, favors, flavors, everything. My file, half the size, the box was this big. And Dory's been around here, and she knows that. So this is not about being fair and helping the businesses. This is, we're going to get you, Damien. We're going to get you. And that's how I'm going to close this, Your Honor.
Okay.
Well,
So-
if he's done,
so-
I do want to sum it up.
You've already
To
summed
all,
yours up.
to all of the, are all the pictures, all the documents, in addition to this, now with you guys?
Here's the other stuff right here.
All right, make sure, all right, verify that everything that you wish to be introduced is there.
Yes, Your Honor. Here it is. This is the
So you have a short summation?
This is the governor's bill.
I'll let him finish, you can hear it.
Okay.
About making sure that they get a proper complaint from somebody that they never got. This is a complaint from city staff.
All right, just summation.
Just a couple of comments, and I'll sum it up. First of all, it's kind of offensive that I think what I'm hearing is that somehow staff is doing something wrong. Staff is doing what they can do under the circumstances to get things done. Second thing he mentioned, which is not correct, was somehow that they've submitted evidence that they've been approved since 2017. The only thing that they submitted was something from ABT, and we've clearly testified that that's not pertaining to our codes in this case. The bottom line is three things that we have to show here today. Number one, that there's a violation of the rule. In this case, we showed that they are in violation of section 54-4-18.2, subsection E. Specifically, as the testimony here today was that they have these unapproved outdoor seating, tables, chairs, bars, grills, etc. It's the first thing we have to show, that there is a rule, there's a code, and they're in violation of it. The second thing we got to show is that we provided them notice. And the testimony here today is that they were given ample notice in so many ways. They hand-delivered, it was posted, it was here on City Hall, certified, signed mail. You even saw a picture of the respondent holding a copy of it over his head. That's the second. And the third thing is that we got to show competent and substantial evidence, and that was ample evidence from both Dory here today and Curtis. Curtis establishing everything dealing with the violation, and Dory establishing the fact that we're trying to work with them, but you got to come into compliance, and then we'll work with the site plan. Then we'll work in getting the site plan approved. So we are still asking, number one, that there's a finding that they failed to comply with a section, specifically 54-4-18.2, subsection E. We're willing to give them an extension till Monday. I'm not sure at this point how long that is, but whatever it is after the holiday to move everything out of the way. We're asking for the administrative fees. We're asking for, if you don't comply within that deadline Monday, we're asking for $100 per day. In addition to that, we're also asking, like we always do, if they do not comply, we're asking your authority and your order, which is the effective law, pursuant to 162.08.5, to go on the property and remedy it, and ultimately we'll be before you again on a massing hearing with a lien. Pretty much that's it. We're asking for all those things, and we believe that, like I said, there has been competent, substantial evidence to support the city's position.
Okay, so are all the pictures in? All
Yes,
the
Your Honor.
documents in?
Yes.
Okay. I'm going to take the case under advisement. You'll be provided with my decision after I prepare it. We're going to take a short recess now, and I ask that we go off the record. Let me know, are we off the record? Okay, we're back on the record.
Yes, Your Honor, the next case on the record is, I don't think there's anyone here, but the next case on the record is Charlie Echo 21027722, is Donald and Arlene H. Baker, 441 Fordham Street, and I'll defer now to the code enforcement officer to present the case.
Good evening.
Good evening again,
officer.
Your Honor. I'm Curtis Bloomfield, B-L-O-O-M-F-I-E-L-D, a code enforcement officer with City of Sebastian for approximately 15 years. This property, 441 Fordham Street, I received a complaint about high grass and weeds at this property. I inspected the property on July 1st, found that it was in violation of section 66-3, parentheses 11 of the city code. I cited the property. Certified mail was sent, certified mail posted. Certified mail was sent, and it was posted on 7/27. I believe someone signed for that mail. Nikki?
No, I don't have confirmation.
You don't have confirmation, okay. Well, I do have some photos. If Barbara could show me the ones that say post in first, violation post in. I think I got it. Yeah, that one. So, yeah, so, huh? It was signed for? Okay, so it was signed for. Okay. So that's the post-in of the violation, July 27th. The other one, that's the post-in on October 21st for this hearing. Was that one signed for? Certified mail was sent. It was also posted in City Hall here. I haven't heard from the owners. No one contacted me. And so I'm asking you to find the property in violation of 66-3.11 and allow me to actually abate this property to, I'm also asking for $100 administrative costs and no time to cure.
No time to cure.
Yeah, as a matter of fact, I need to show could I see the grass, the photos of the grass? That's what it looks like, Your Honor. And I am trying to get it mowed for Thanksgiving so the neighbors can have something nice to look at.
Okay.
So I'm asking for no time to cure.
So certainly, people had plenty of time to show up, and there's no one here in the chambers, and I do not see anyone out in Zoom land. Am I correct?
That is correct.
Okay. So, anything to add, Mr. City Attorney?
So you're asking to go immediately?
Yes.
By when? What date we're giving them?
I'm trying to have it mowed tomorrow.
Okay, so then this
I'm asking for no time to cure. I want
So then
to.
we got to change the order I gave you. All right, so, okay, that's fine. I have nothing further. I'm good.
Okay. Hearing no objection, so ordered.
Thank you, Your Honor.
There will be no daily fine on that one until they,
No, there's no date to find because I'm going to have it mowed tomorrow.
okay.
Oh, okay.
Yes.
Can I proceed now, Your Honor?
Yes.
Okay, we're moving on to the last two cases. I know Code Enforcement Officer Keeney has been here since 2 o'clock waiting to testify. So we're here on two lien cases now, two massing hearings. First one is Code Enforcement Charlie Echo 21004419, Edward and I guess it's Casilia Parker, 1221. I assume that's George Street, and I'll give it to Code Enforcement Officer Ikeni to present the case.
Good evening, Your Honor. My name is Richard Iacchini, last name spelled I-A-C-H-I-N-I. This case was brought before you in a previous case. It was abated, and we had it taken care of. We sent certified letters out, but they were returned undeliverable. So we're asking for a fee of a lien of $399 82 cents, and that includes the administration cost.
If I can, I just want to add one thing. Is there any, I'm talking now to the clerk, because I sent an email and I never got any response. Is there any $250 a day fine on this one, or there's no time in between, by time the date, which was August 4th, until it was cut? Is there any date?
We had it abated the day, they had 10 days to get it done.
Right.
And on the 10th day, it was abated.
Okay, so then I strike that. Okay, so then that is correct. All we're asking for is the $299.32, which is the cost for abating it, and $100 admin fee, correct, sir?
That's correct.
Okay, then that is correct, Your Honor.
Okay, no one here is in the chambers. I do not see anyone out in Zoom land. So they're hearing no objections, so ordered.
The last case, Your Honor, is case number Charlie Echo, Code Enforcement 21008258. It's Angus.
Mike.
Sorry?
Mike.
I'm sorry, the last case is Charlie Echo 21008258. That's Angus B. and Nora T. Joyner. That's 322 Biscayne Lane. And I defer now to the Code Enforcement Officer to present the case.
Again, Your Honor, this case was brought before you before. The history on this property is there's like 4 names on it that inherited this property, and nobody wants to take responsibility for it. I have spoken to 2 of them over the phone, and they said, just do what you got to do, abate it, and lien the property. So with that, we had it abated, and we're asking for, the letters were received, but that's when they called and said they didn't want to have anything to do with it. A total of, we're asking for a lien for a total of $813.85, and that's administration's included. So that would be $713.85 for the abatement charges and $100 the administration fee.
Nothing further.
Still no one here in the chambers. Still do not see anyone out in Zoom land. So with no objections, so ordered.
And that concludes our day today of our cases, Your Honor. I appreciate your patience, and also all the staff.
Yeah, and happy holidays. Happy Thanksgiving.